Because the client did not respond. I was required to file an application on
Criminal revision
revision,
against conviction.
conviction.
Can't dismiss it like this.
I cannot argue because
I know, I understand your problem, but what to do?
Amicus curiae, your lordship.
Your lordship.
I will appoint you as amicus curiae.
Sorry. I cannot take it. No, I'm grateful, but I cannot take it down.
You ask the court, who else can do better than you?
On merit, I do not have a case. On last occasion, it was my specific submission that yes, I am raising a point of Section 4 Probation of Offenders Act. Your lordship directed me to file an application. Despite my repeated approach, since last 10 days, he did not respond.
No problem, sir. You make a oral prayer, I will allow that. Be there. You are the best counsel for this matter.
One criminal miscase matter, fresh admission matter.
You make a oral prayer insofar as Provision of Offenders Act is concerned. Or through counsel also you move application also. Why unnecessary?
That was
130 one fresh admission matter.
Please.
And another is that will be disposed of that is medicine is successful. So that will be disposed of.
What? Sorry.
One criminal miscase matter. We went to mediation and mediation is successful.
Successful.
Yes,
So that you will
Yes,
will take it up.
And one fresh admission.
Which one is the mediation one?
Second one.
Don't say second one.
Yes, this
This one.
criminal miscase 1137 by 2013.
You take it. Release it immediately. Tomorrow.
And
Tomorrow?
fresh one yes, one fresh admission.
Fresh admission will see.
Fresh admission matter, my lord. So, 130 enact matter, my lord. The party has taken all the money, my lord. Subsequently, I demand he has taken a check for advance that amount. That check has not returned, my lord. Subsequently, he has filed this case, my lord. Kindly taken up, my lord.
You give the memos.
Fresh admission matter.
Fresh admission will come. Don't worry. Give. Please give. Madam, please give the memos. We'll see.
Tomorrow.
Not tomorrow. We'll just see.
That is why the charge is coming up.
It's all right. We'll see what can be done.
My lord,
Give all memos. Give all memos. We'll see. Priorities by which we'll do.
Pardon, my lord. Modification of order.
What modification?
Modification of order. One order is passed, their case number is incorrect.
You might have written like that in your
The problem.
prayer.
Yes, ma'am.
देखो modification ले लो.
Problem.
Give all the memos we'll give. We'll examine.
Yes.
Yes.
Fresh admission.
Now, please.
On vigilance appeal, criminal appeal, 3 years conviction, even bail, man. Marcel and Tiger.
Press matter.
Yes. Marcel and bail ଅଛି.
हाँ.
3 ବର୍ଷ conviction ହେଇଛି. File ହେଇଗଲାଣି Marcel and.
389. 389 benefit.
Yes.
Or least it. 389. 3 years sentence. More than 3 years.
ଆଜି ଭିଡିଓଟା ମାସେ ତ ସେ ପୋଲିସ ବାଲା ତାକୁ ହରେ.
No problem. We should
I
do,
may be,
LB.
I may be excused, my lord. Item 109.
109.
Lordship.
Yes.
I pray one week after. I could not contact the petitioner.
There are some judgments. Let me pronounce.
Yes, yes, ma'am.
I'll pronounce the judgment.
Item 14, my lord.
One minute. Let us pronounce the judgments.
The judgment item 1.
I've analyzed the entire thing thoroughly and postulated the grounds on which the cases of this kind could be quashed and para 33. Thereafter, applying these principles and the guidelines, I've quashed all the 5 cases, FIRs of all.
Okay.
And I have appreciated the efforts made by the MFA.
Pardon,
Yes.
Sir, modification order passed by the Lord ADJ.
Ganjam. The petitioner is staying the Bhubaneswar, my lord. And the Lord ADJ passed the order daily per weeks on Sunday. He appeared before the police station.
What is,
The condition was the fixed by the ADJ Ganjam.
what is the problem? You.
My lord, I file a modification of.
Give it. Yes, yes, 109. 109, 1 week. But get ready, we'll finish it.
Yes, ma'am.
May I pardon, my lord?
60, my lord.
One after another.
Item 14, my lord.
14,
2 weeks after.
14.
My lord.
14 will come within 14 minutes. Why are you mentioning?
Item 40, my lord.
Oh, here is a 14, let us see. First, this is the fresh matter.
My lord.
Now after notice.
On behalf of
My lord,
It will come in July, I tell you. Fresh matter you are asking adjournment, it will come in.
item 40, my lord.
2 weeks after.
Pass over. তিনটার উপরে মনে পকি কইবে
Item 60, my lord.
এখন যান
My lord, item 60.
16
60.
6 হ্যাঁ ফুল
Kindly taken 1 week after.
নাই ফ্রেশ ম্যাটার আফটারনুন
Yes, madam.
ফ্রেশ ম্যাটার না ফ্রেশ ম্যাটার না
Out of station.
My lord,
One
criminal miss case 2022 for orders, my lord.
which item
It has been added.
memo you are giving
Yes, yes.
May I please your lordship?
memos you give
May I please your lordship?
Yes.
26 witnesses there, my lord. 8 witnesses are relevant, my
It is
lord.
restoration
But
matter.
they,
Restoration.
on 24th ରେ ସେ ଡିଫେନ୍ସ ୱିଟନେସ୍ ପକେଇଛନ୍ତି କିନ୍ତୁ ପ୍ରକୃତରେ ଦେଖିବାକୁ ଗଲେ ସେ କହୁଛନ୍ତି ମାନେ ଆର୍ଗୁମେଣ୍ଟ ପାଇଁ ପକା ହେଇଛି ପେସ୍କାରଙ୍କୁ ପଚାରିଲୁ ଯେ ଫୋନ କରି ଆଜ୍ଞା
ডিফেন্স উইটনেস ପାଇଁ
ଏଇଠି ହଁ ମାନେ ଏଇଠି ଲେଖିଛନ୍ତି କିନ୍ତୁ ମୁଁ ପଚାରିଲି ସାର୍ କଣ ପାଇଁ ରହିଛି ନା ଆର୍ଗୁମେଣ୍ଟ ପାଇଁ ରହିଛି ଇନ୍ ଦ ମିନ୍ ୱାଇଲ୍ ମୁଁ ଏ କେସଟା ଫାଇଲ କରିଛି ମୋର 8ଟା ୱିଟନେସ୍ ନ ହେଇକି ସେଟା ହେଇଗଲେ ମୋର ଇନଫର୍ମ ଆଇ ଆମ୍ ଫର ଦ ଇନଫରମେଣ୍ଟ ମାଇ ଲର୍ଡ
what is this matter is
that is under section 430 or 493.
no I am talking about this is 311 application
Yes, my lord. So it is very urgent, my lord. 24 तारीख रही काली की नहला सु your lordship.
काली नहीं परिवन
My lord, no after lunch,
you take it and just see
my lord, it मध्ये देची your lordship. हाँ.
he will see
Yes, my lord. Pardon, my
Pardon, my lord. Item 69. Paper 1 week time.
16
69.
why
On behalf of Mr. Rautray, he's
you
badly.
can argue
He's badly present.
I didn't कर दो it is after notice who is the other notice not service you interim order must be there
No.
No.
Pardon, my
Oh,
lord.
bless me.
I want to mention this is against the discharge petition.
give the mail yes
I may be pardoned to make a mention, let's say,
yes
that let's say I am appearing on behalf of Sarthak Naik, counsel for CBI, item 6 and item 60, praying for an adjournment, let's say.
these are after notice matters
Yes, let's
wait
say.
the other side should come I let them read but the other side
I'm here.
yes yes sir.
Item number 6, I am here.
60,
Item
let-
6 six
I am there.
he's asking for an
6,
adjournment
6 and 60, let's say.
60 all right first 6 let us
Number 6, my lord, this is a matter, since long it is pending, and your lordship, my lord, after they have searched for time, and thereafter your lordship adjusted your calendar for this. And this is a CBI matter, and with regard to seashore, I am a government employee, and I have been implicated by way of 41 notices, 160, thereafter 41 notices, 41A, for which, my lord, I have no case for them, my lord. I can show it, my lord, that within half an hour that no case has been made out against me. I am no way concerned with the money circulation scheme. No way concerned. I can say with this, my lord, I am no way concerned. And section 3(4) read with 2C doesn't applicable to me at all.
okay what is the stage
My lord, the case is, my lord, I am a
what is the stage now
They are issuing notices in 41A repeatedly. I have appeared. In 160 notices I have appeared. 41
The
notice
investigation is
still on. And for 4 years it is still on. And I am a government employee. I have retired as a director. Then thereafter, Miller, I have nothing. I have just given a note to the approval for this, and nothing with the seashore company, nothing with this, Miller.
They may file a closure report against you.
Miller,
They may file a closure report.
Miller, they are not, Miller. They are not doing this. Last 4 years I am suffering. 6 years.
Yes, there is an opposition for adjournment. What do you say?
Let's see, counsel for CBI Ms. Sarthak is due to some health difficulty, he is not present.
This is 6
Keep
years.
on
Maybe
giving-
urgent for tomorrow, let's say. He is not present because due to some health difficulties. He just informed me, let's say.
Then see, you can't prolong the investigation for such a long time and keep on giving notices after notices. If anything is there, it's all right. If it's not there, file a closure report and finish it up. You see, because of your delay only, you are forcing the accused to come to the court. So you seek instruction. We'll put it
I
in
seek
Friday.
instruction from.
Friday, sir?
Friday.
Friday. No
Friday.
further adjournment.
Much obliged.
Mr. Jena, Mr. Simpson Jena, on behalf of Sarthak Naik, counsel for the respondents, seeks an adjournment. The adjournment is granted, preemptive adjournment granted, and we see matter of ready for it. Friday, be ready so that we can finish it up. Okay?
So, my lord, kindly record my senior's appearance and
Yes, sir.
Mr. Sanjit ma'am,
Along with Mr.
and the submission, my lord, because they have delayed that part, but they have to instruction.
Friday, I will finish it up. Water.
Oh.
Friday. I will do it.
Item 7.
7, my lord, next week.
Next week.
Item 8.
Yes.
Wait, my lord, that will be compromised between the parties, my lord. And opposite party, they belong to my lord, a finance company. They have been transported to some other places, my lord. Now they are not in a one company.
But what happened in this case, my lord? Earlier occasion, your lordship direct my friend to bring the accused person. Here, the informant, my lord, came
Yes.
forward and filed the application for quashing of the
On the ground that
proceeding, my lord.
I'm
Accused
submitting,
are
my
not
lord.
there.
Accused not there.
Just a minute, I'm submitting, my lord. FR is filed on behalf of the petitioner. Police submitted final report, my lord. The case is closed. Now the court has somewhat taken cognizance against.
All right. It's settlement. I am not on that.
My
Where is the accused? Why can't they
Exact-
appear online?
lord, accused, my lord, now they are a finance company in Magma Finance, my lord. Now the company, my lord, they have been closed and they have been
But
different
online,
locations.
I am not saying that they should come to the court. Online, they can appear. But
But-
Earlier, you also direct them to appear through the
Yes,
IAC, my
yes.
lord. But they did not, my lord, appear
IAC,
before the
no,
IAC.
how they could go to IAC, my lord? Now in different state they are moving in the
so
government.
you ask them to appear online.
But can they authorize any person to appear, my lord? That's
No. What is this?
yes, yeah.
Accused are not VIP.
yeah, that's
Otherwise,
fine.
it can't be because let them
That's the
suffer.
whole problem, my lord.
I'm giving that liberty that they should appear online.
We see.
Online. So somebody has to, we don't know what exactly has transpired.
Exactly,
It's
yes,
good
yes.
for you also. Unnecessary, don't take that.
Yes, engage them in.
Tell them to appear.
Next.
You tell me the date, time, I will fix it. I'm passing it over, ask them. If they can appear today also, I can finish it.
Pick him, my lord, keep it to my lord next week and at least I can
Next week.
next Monday.
Next week. You tell them to appear online, okay?
My lord.
Okay.
Item 9.
Item 9, I may be permitted through VC, my lords. I
Yes.
may be permitted, my lords. My lords, in this application, the petitioner seeks to challenge the order rejecting the petition application under section 311 CRPC, my lords.
Yes.
This matter relates to a 138 enact proceeding, my lords. And
You are accused.
I am the accused in that case, my lords. On 29/4/2022, PW1 was examined and cross-examined, my lords. But due to inadvertence, my lords, some important questions were left out. For which,
What are the important questions? You have not said
Hello.
anything in the application.
yes, no, I have, my lords. That
Yes,
is, lordship kindly see, that is page 13, my lords. Page 13 is the questionnaire, my lords.
Yes, I can.
Page 13, 8 questions are scheduled questions, my lords, which are to be
What is
put.
the check amount?
Check amount, my lords. 3,50,000, my lords, it is so.
What kind of questions, whether you
My
trust
lordship,
the sarpanch of your own panchayat or not? He will
no,
say
no,
that
my
whether
lords.
I'm trusting or not.
My lords, some important questions like that, that is, whether you have lent that amount of money
All
at
are
a time, my lords. So only one chance may be given. I will not take any further adjournment, my lords. Only
But
single
anyway, we will see, what is the check amount you said?
3,50,000 as per the complaint case.
Why
my
don't,
lords.
why don't you settle? Will you settle it?
Lords, that part I have to take instruction, my lords, without.
I'm simply issuing notice, issue notice.
Somebody appearing, my lord.
Somebody has appeared, your lordship.
Vishnu Prasad Rath.
Yes.
Line, item 9.
Acha, nine.
So only
Acha,
single.
notice has already been issued. No? Yes. Let us see who is appearing. Wait, I'm passing it over. Let us see, somebody name is reflecting, he may come. I'm just passing it over, okay?
So your lordship will take it at 2 p.m., your lordship.
Yes, 2 p.m. Yes.
Item 10. Item 11.
Ashok.
Item 12.
Cognizance is taken under section 497
Yes.
and 506 to 94, my lord. And by the judgment dated, my lord, Joseph Sign and Union of India, that section has been declared, my lord, unconstitutional.
294, 497, 506.
506 is also not well made out, my lord. The only last.
But prior to pronouncement of judgment 497 IPC, my lord, by the constitutional bench of the Supreme Court, but the FIR was registered prior to that, my lord. And judgment pronounced on 27/9/2018. The FIR registered, my lord, 24/4/2018.
But why don't you argue in
And
the trial court?
my lord, exactly.
Why have you challenged cognizance? These are the questions where at the stage of framing of charges, you have to argue. Right, Land Counsel for the petitioner seeks to withdraw this petition with the liberty to argue all these points before the trial court at the stage of framing of charges. With this liberty, the petition is disposed of. Yes.
Item 13.
Yes.
Sorry,
Thirteen.
OPID matter, my lord, they have to serve copy on the OPID.
Yes, we have served the copy, my lord.
Where is OPID?
The moot.
Pass.
No.
What to do? Pass. Somebody has to come. Yes.
Item 14.
14.
14.
3 chapter on behalf of Mr. Hon'Ble.
Urgent.
Item 15.
Yes. Coming here. 15. 15 special adjournment. Pass over.
16.
16 minutes on behalf of Mr. Chandan Samantra on due to some personal difficulty, minutes 1 week after.
17.
Grateful minutes.
Pass over.
18.
Display board.
So,
19.
Lordship. Lord, here the petitioners are sheltered persons.
Hmm?
the petitioners are scheduled tribe persons.
Hmm.
They have filed this application challenging the criminal proceeding as well the undertaking the cognizance order
Hmm.
because the dispute between the tribal and non-tribal persons. The allegation was the tribal persons, basing on the forest land, with the tribal person they have right over the forest lands, but non-tribal persons they raise dispute. The petitioner being the tribal person, they entered their agricultural fields and the dispute raised, and these allegations are given by the informant blood, the wife of non-tribal person's blood, blood the as per the act, Milord, first of the cognizance has to taken by the special code, this special act, Milord, not by the SDGM. That has been taken by the SDGM. That's Annexure 2. Then SDGM taken the cognizance order Annexure 2, Milord.
Yes.
That is page 14. That has been SDGM KUR.
143, 147, 294.
Yes, yes. Yes, that has been taken by the SDGM instead of that is special act.
Where is the charge sheet? Let us see.
Right, yes.
Charge sheet.
The charge sheet action filed by the that has to be filed by the DSP or the investigation done by the inspector IAC instead of DSP.
Where is that?
Yes, that is the Lakshman. I see the.
No, it is not annexed. Not annexed.
No, that charge sheet I have not annexed. That must
No,
be.
that is necessary
Yes,
because
Lakshman, I see that.
Challenging your entire case is on the basis of that charge sheet.
Charge sheet. It not a charge sheet.
Where is the charge?
Yes, but that charge sheet I have not filed, but the pattern was
Your place on record the charge
yes,
sheet.
but the charge sheet blood.
Because for the petitioner takes time to place on record
But
the copy of charge sheet.
May file the but now I have the
Let him do so within a week. Release the matter next week.
But said date fix question appearance करे but मते
That's what to do.
Let's
You are
protect me.
challenging the cognizance order. You don't file charge sheet.
Charge sheet but the final form I've got the
What can I do?
that protect me but I file.
How can I protect you? You have filed an incomplete petition. How can I protect?
That's
I can't help you. So next.
Let's fix the date so that better.
Here next week.
Next.
Yes.
Item 20.
Your entire case is inspector has investigated, DSP has not investigated.
Yes.
How will I know? You have not filed the charge sheet.
But in the meantime, Lakshman direct the state council to bring the records so that
I'll
give that. That is in the meantime. In the meantime, Lakshman direct that. Let them bring the record. It will otherwise on my documents.
They have all record. Next 20.
20.
Yes.
Password?
Password.
21.
Password. You finish all the kacha pages and earn money thereafter come.
I am also in item number 15.
I have passed it.
Item 21 the same.
I am obliged to.
Yes.
Item 21 the same.
21
The
also.
same. Next week.
21 also. Next.
But I pray that Lakshman direct state council bring the all records.
He is hearing you. Don't worry. You get all the.
Unless Lakshman direct the minute.
Mr. Rahul. Mr. Rahul.
My lord.
You please get the record so that.
That's it.
Yes. Okay. All records include charge sheet.
22. Yes. May I please?
The matter is to release the vehicle of the present petitioner, my lord, which was seized on 7/9/23, my lord. Having more than
2022.
in conversation 2BCC case number, my lord. That
Where is the order?
order, my lord, page 10.
Page 10. Yes.
My lord, on perusal of the case record under section 450 service petition, it is found that subject matter the matter in which case is that above stated vehicle has been seized by forest.
But against this, you have to file a revision before decision.
Lordship, they rejected my.
That's right. JMFC has passed this order.
Yes, ma'am.
Against this, revision lies before the sessions court.
That is there, my lord, but Vehicle is since last 8 months.
That's right, you may be correct, but you have to file the revision.
Because
Right.
they,
This present
Your
petition is
Lordship,
filed against the order.
the only ground of rejection, my lord, that
I'm not on the ground, sir, I am only maintainability. What is this? Filed by the petitioner against the order dated 25/1/2024, passed by JMFC Burville. On the application moved by the petitioner under section 457 CRPC for release of the vehicle. Against the said order, since revision lies before the Sessions Court, he seeks to withdraw the present petition to prefer appropriate proceeding before the court below with the aforementioned liberty. The petitioner.
if lordship delays there, they may be found.
Oh, section 14 benefit you will get.
That observation of
Benefit you will get, I am giving liberty. No,
a limitation.
no limitation. I'm giving liberty, then
Ah.
yes, to, if such application is moved, the
Yes.
same shall be considered on its own merit.
Okay.
23.
Sorry?
The 150 case has been filed by the complainant
Yes.
that he was the owner of the land and accused or forcefully got the paddy. This is the allegation. Actually, my lord, kindly see annexure 3, page 15.
Hmm.
This is the land of government of Odisha.
Hmm.
And annexure 4, I am encroaching and giving the,
What is your case?
my lord,
What is your case? Why it should be quashed?
a false allegation has been,
That will
Lot-
be tested in the trial.
yes, my lord.
Huh? So why you have come at this stage of cognizance?
False allegation has been made before
How
the,
can I test it whether it is false or
that I am giving the
no? I
certified copy,
I can't.
certified copy of the ROR. my lord.
That's right. All these things you have to tell in the trial.
Allegation is plot number 155.
Sir,
That is in government
at
khata. He
this
is saying,
at this stage, initial stage of taking cognizance, I can't conduct a mini trial to know whether your documents are correct or not. It has to be tested. Who knows these documents are correct or not? What objections the other side has? Nobody knows. So therefore, you have to resort to the right remedy before right forum. Right down. Then counsel of the petitioner seeks to withdraw the petition to raise all the points before the court below at the appropriate stage. With this liberty, the petition is disposed of. Yes.
24.
Yes.
Here, my lord, a case under section 376 2N and 506, my lord, was registered by the victim opposite party number 2, my lord, on the ground that the present petitioner raped her and thereafter, my lord, with the false promise of marriage, he kept relationship and thereafter they have lived together as husband and wife for 6 months. I have also annexed, your lordship may kindly turn to annexure 2, page 15, the statement of the victim girl, my lord. Here, my lord.
What happened on
Thereafter, my lord, charge sheet has been filed and thereafter I have filed a petition for discharge under section 227, my lord, and the said petition was rejected. That is under annexure, my lord, 5, my lord. Annexure 5, your lordship, at page
376 2N is not made out according to you.
Yes, my lord. So, on the false promise of marriage, it is alleged that they are
Show me the statement.
Statement is annexure 2, your lordship, may kindly.
at the page,
At page,
Read it out.
page 15, my lord.
page 15.
Read it out.
Yeah, in the more नाम महेश्वता बलियार सिंह पिता सो एंड सो 26/12/2000 आपन निकट देवा फुलबाणी एक जे गत 2017 मसिया रे मु फुलबाणी ऑटोनोमस कॉलेज +3 कॉमर्स पढुतली ଚିତାଗୁଡାର ବିପିନ ବଳିଆର ସିଂ ସେଠାରେ +3 ଆର୍ଟସ ପଢୁଥିଲା। ତାର ବଡ ନାନୀ ଅବନ୍ତୀ ସିଂ ଏବଂ ମୋ ଜ୍ୱାଇଁ ଧର୍ମେନ୍ଦ୍ର ସେମାନେ ମତେ ବିପିନ ସହିତ ପରିଚୟ କରାଇଥିଲେ। ମୁଁ ଫୁଲବାଣୀ ନାରାୟଣ ସାହିରେ ଘର ଭଡା ନେଇ ମୋ ସାନ ଭାଇ ଭଉଣୀଙ୍କ ସହିତ ରହୁଥିଲି। ମୋର ସାନ ଭାଇ ଭଉଣୀ ଗାଁକୁ ଯାଇଥିବା ବେଳେ ମୋର ଏକୁଟିଆ
SDJ Udala order passed by SDJ Udala.
Where is the revision court order?
The operative.
There is no marriage, valid marriage.
No, there is no the operative.
There is no marriage, valid marriage.
No, there is no marriage. Has filed Annex 5 and enrolled in the meantime, enrolled already been issued. The respect on petition 2 in the view of decisions 1 so and keeping in mind the present cost of living, the opposite party, namely Prasanna Patra,
And
that has
for the mother, nothing is given.
mother has not proved by his wife. How the child has born does not also prove, and that does not move before the court below regarding the DNA test, other family. But the court below,
125.
Yes.
To the opposite party. And NBW, where is NBW order?
My lord.
SDJM Udala. Why it's order dated 2024 is date till next date approved.
27.
Different laws. Cognizance have been taken under section 84, 85, 86 of the RCFT LAR. It is right out law. The officials will be prosecuted. The petitioners over here are the officials of money to be paid is decided after 9-1 notification. Document issue notes and tag this matter with those applications. All the matters can be heard.
Same issue?
Same issue, Your Lordship. Page 62 of the brief may be seen. Page 62 of the brief.
62.
Yes, the cognizance order.
62.
Yes, the cognizance order. Where the cognizance has been taken under 84, 85, 86 of the.
Yes. Mr. Sarma, and counsel for 2020. The petitioners are the officials of MCL and the
Has been paid.
From
These are
law.
43 of the brief. I've given the
compensation in regard to the
structures of the CBI Act, Coal Bearing Act.
28.
PC mode, my lord.
Yes.
The wife of yes, Roman 2, your lordship, wife of the complainant, Srimati, proprietor of Mega Fuels, in the outlet of IOCL located in such and such. Through the proprietor, how the husband of the proprietor can file a complaint case against me and realize money. Your lordship may see page 10, who is the complainant. Proprietorship doesn't file the case, the husband files the case and the case is instituted.
Complaint case. And, file this application for a challenge for a modification of the order, my lord, page 24, my lord, annexure 2, my lord.
24.
24 page.
Annexure?
Annexure 2, my lord.
Yes.
3/4/224, my lord. Annexure 3, sir. Annexure 3, page 24, my lord.
24, yes.
The matter is fixed for a
case filed.
130 NI, my lord.
What do you want? Accused is present and the counsel for the accused files a petition free for time. No substantive ground made out for time. Several oppositions given and the petition filed with the counsel for the accused is rejected. Heard the argument. Full for.
I see some time, my lord, to adduce my defense evidence and
You are the
argument,
accused.
my lord. Only
Time?
last chance.
Enough time was granted.
My lord, I admit.
You have not availed the.
My lord, the last chance, my lord. What has happened, my lord? The check has been issued by the opposite party, my lord, too. And I see, I'm not liable for the check amount, my lord. He has cheated me, my lord. I have mentioned the fact of how he cheated, my lord. I have given a blank stamp paper and a blank check.
Nothing is left to consider. Only evidence.
That is, well, that is, I have executed sold it, my lord, and the amount is fixed for 3 lakh.
You had a good case. Why have you not availed the opportunity granted to you several times?
My lord, did you illness, my lord, and mentally pressure, my lord? I give last chance, my lord.
24th is the day for argument.
23, my lord.
23.
My lord.
Yes.
Oh, that you
I
last
have
time.
to, I can't do it ex parte. I have to issue notice.
My lord. Last chance, my lord.
Tomorrow is not able to.
Tomorrow is that
Tomorrow is
fixed.
20. What to do?
My lord.
Madam, issue notice to the opposite party, of party, returnable next week, karo. And the counsel for the petitioner submits that the matter is fixed for final argument on 23/4/2024. Therefore, he would move appropriate application before the court below, seeking an adjournment for a week, owing to the fact that the matter is subjudice before this court. If such application is moved, the same shall be the judge.
I feel file I am, my lord.
You have to do it. I am giving this much
Subject, my lord.
because you have a indifferent
Apna
right.
Adi sir, your lordship may kindly direct to file the request today.
I'm fine.
Request during the course.
My
of
lord.
the-
And order in custody, I'll file.
Yes. 41.
That's my lord.
Yes.
The petitioner seeking quashing of the FIR, my lord, on the ground of jurisdiction, my lord. The actual fact of the case is that, my lord, the FIR has been registered presently against the petitioner by the Annexure 1 in the year 2024. The fact is that, my lord, in the year 2011, two persons have expired in the road accident and their family members have filed two MSCT cases before the Justice of Berhampur, my lord, way back from the place of accident. That is the Aska police station. And the petitioner's vehicle is involved in that accident, my lord. And the year 2024, the counsel for the petitioner, by the Annexure 2, filed a petition, page number 19, my lord. I filed a petition for cause production of the insurance policy cover note details, my lord, because the insurance is denying that the liability to pay the compensation amount. And the petitioner counsel has filed two policies, and the present petitioner, being the owner of the vehicle, has also filed the same policy. But the insurance company appeared and contesting the case and filed two fake policies, my lord, containing the GST and barcode, my lord, which was not introduced in the year 2011. And also registered one FIR in the name of the present petitioner before the Aska police station. They have no jurisdiction because the family members and the present petitioner, being the owner, residing at Berhampur.
You may be residing there, but
My lord.
if the crime is committed somewhere else, the
No, my lord, the allegation of the insurance company office is at head office at Bhubaneswar, my lord. The case is pending. I'm just placing, sir. The case is pending before the Justice of Berhampur, sir. And the present petitioner, the owner of the vehicle, also residing at Berhampur, sir. And the case is pending. So the jurisdiction is the Baidyanathpur police station. Instead of that, they have registered a FIR at Aska police station, which has no nexus with the case.
Yes, Mr. Maharaj.
No, my lord.
Huh?
This is rightly registered there.
Right.
There
Tell me.
nothing. It is not the, but it's initial stage. Only affair registered, investigation going on. Whether the jurisdiction comes under the purview of the petitioner or not, that will be considered at the end of the investigation. Now, question is, the vehicle has been made an accident. Entire thing is there, it has been mentioned in the.
It can take Hinjili cut.
Yes. Entire thing has been mentioned.
Sir, they are alleging that a petitioner has filed a fake policy before the Aska police station and before the Justice of Berhampur. And
No, there is something has happened in the Aska also.
Aska accident took place, man. Only the accident took place there, but all of them residing at the Justice of Berhampur.
Part of the cause of action is.
That is the.
Man, true, man. I'm not denying, man. But the allegation is that they have filed the fake policy, and before the Justice of Berhampur also they have filed.
You started your argument saying that it doesn't have jurisdiction.
No, man. I'm just saying, man. Praying
the FIR itself. It is written in the what has happened in Aska, Hinjilikat and Aska. Aska headquarter by riding a motorcycle wearing so and so on the way between so and so accident has taken place.
May I submit, man? But the insurance company is claiming that though the policy copies has been filed in the before the Justice of Berhampur and the petitioner is residing at Berhampur, whatever may be the allegation, they have to lodge at Berhampur, my lord. The jurisdiction of the Baidyanathpur police station.
Investigation Aska police station has jurisdiction, no doubt about it. Partly.
Partly, sir. They may be directed to if they want.
Accident case,
They-
not a case of.
They are alleging that 420 allegation they are praying.
That will take it on
At
course.
this stage, I will not interfere.
Well-
Will you withdraw or accept?
I may kindly be protected. I will cooperate. I may kindly be protected.
482 court is not here for protection. Go
Well-
to some other court.
No, my lord, I am just placing my lord. But on the ground of jurisdiction, I am praying for
Let
the
counsel for the petitioner seeks to withdraw this petition to avail his remedy under law by resorting to the proceeding under the court with this liberty dispute. Yes. 42.
These are those complaint petitions under the Income Tax Act.
Yes.
Previously, your lordships have passed some orders. Kindly, my lord, turn to page 59.
What are the delays? Delay? Extent of delay?
It's not delay.
No, not delay.
Thrice they have filed, we have given notice thrice. He didn't file the return time. Thereafter, the cases.
Not filing of return.
Now, let me just address your lordship.
Yes.
Kindly see page 59.
59.
This is the order of the appellate tribunal. And I will deal with the delay in filing the return also. My lordship sees, my lord, page 59. This is the starting of the order of the tribunal.
Right.
And if your lordships are kindly pleased, my lords, to come to page 115.
Yes.
Para 43.
This is for the financial year.
This is for financial year, my lords. 6-7. There was a batch of cases.
2006 and 7.
Yes. My lords may kindly see para 43.
Yes.
The above noted factual metrics of the present case clearly show that approval had been granted in a mechanical manner without application of man. The initiation was itself bad. And thus, no valid approval has been granted by the learned ACIT before authorizing the AO to pass the assessment order under 153 of the Act. The required mandate of section 153 of it has not been satisfied. Accordingly, we hold that all assessment orders are vitiated. Kindly note, my lord, and thus the same are void. Has been bad in law. We accordingly set aside them. Now, what happens is, just this one. At page 128. Kindly note, my lord, tribunal and the orders are void. Now, kindly see page 128.
120.
128.
120.
Annexure 7. You know, this is an appeal filed by the department against the other assessment order in question. And if your lordships are kindly pleased to change down to page 143, paragraph 25, 143, paragraph 25. Your lordship uphold the order of the tribunal.
140. Yes.
Now kindly see the department gives an appeal against the common judgment to the Honorable Supreme Court at page 145. Now there also essentially dismissed. So order is void, upheld by the lordships, upheld by the Supreme Court. I will say that one other order. There was a penalty proceeding also initiated. Now kindly see that will start at page 123.
123.
123.
Yes.
Kindly now turn to the page 125 and let us see what was the submission there.
Submitted by the
It is submitted by students. The quantum order of the relevant assessment years under appeal have been quashed on technical grounds. Kindly note that. On technical ground, the violations of provisions of the VD of the Act, the merits have not been adjudicated. It was the submission that the merits showed that there was concealment. It was the submission that merits have not been adjudicated, nor the addition of it has been deleted after considering the merits of the case, but the orders have been cancelled on account of technical. It was the submission of the SSC was subject matter of search being course of search when so and so has been surrendered the income, but the same has not been offered to tackle it. With the further submission that Review has filed an appeal before the Jurisdictional High Court of Orissa against the order of the tribunal, quashing the assessment in violation of 153. It was the submission that as merits have not been considered and the Revenue has categorically approved concealment, penalty so and so confirmed. Alternatively, the submission that the appeal be kept in abeyance will dispose of the appeal before the Judicial High Court. Now, kindly turn to page 5, page 126, paragraph 5. We have considered the submissions of so and so and the submissions filed by the SSC. Perusal of the written submissions filed shows that SSC has categorically stated that if appeals of the SSC are not being allowed then the assessor should be granted an opportunity to file written submissions. Here it is the fact that the quantum of it would be very important. That the quantum appeals in respect to the SSC for the relevant assessment has been allowed and assessments have been quashed on account of the alleged violation of provisions of section 153 because it is noticed that the assessments have been treated void and bad in law and consequently the same have been quashed for the purpose of levy of penalty. Kindly note, madam. For the purpose of levy of penalty, there must be an assessment order and there must be a quantum. Let us say, I have been assessed to tax of 1,000 rupees. So penalty will be on that 1,000, right? So if that 1,000 is no more there, I'm going to kindly read the next. Consequently, there is no quantum available on the basis of which penalty could be levied. Thus, the penalty orders have no legs to stand.
So the penalty is also.
Everything is gone.
Now, mine is this also technically, statutorily, the prosecution can go on.
I'm getting. Can't be on. Because the basis is not.
That's the.
No, therefore, no, your lordships have kept it to final hearing, I think tomorrow the entire batch. These are 2 more cases. So here I'm just, the lordship just a moment.
If you, that Radhesham Agarwal judgment, if you bring the issue of that, if in the adjudicating process, if the person is generated, then the criminal prosecution is a legal exercise.
But the difference is that because all documents are not with me, I have part-time literate. Page 51 estimates so many documents they have filed. And in that next page 52, it is ending on page 53.
On merit on fact, I have is not.
No, what I am saying, my lord, the cognizance order, because in the time of taking cognizance, they have exonerated. What not saying the issue is coming, they have exonerated, the court below has exonerated some persons. Against which the government of Union of India preferred file appeal, that is page 54 to CC number 18 of 2015. In that case, an order was passed, Lord, you may see for a moment, page 58.
58, yeah?
Yes.
Yes. Yes.
Yes. In that order, the London Court below was elaborately substantiated about that first part I am just reading order. This is a common order arises out of the 8 separate petitions filed. I'm page 55. I'm reading 55. Yes.
Yes.
This is a common order arises out of the 8 separate petitions filed by the accused person 2 to 8 under 205. They have filed a 205 application for the for person on 25 2017. They have arrived in their petition that the accused number 2 and 7 are the joint managing director of the Sirajuddin and company, and the accused number 3, 4, 5, and 6, and 8 are the partners of the Mess Original company. There is a true status of the company where the notice has been issued, and whether what my land senior is cited upon 54, some people are coming, we can always say partner of the company, that means they are a separate legal entity. And those some persons are coming in the company, those are in separate legal entity. So which case, what order has been passed, I have to attend. Because this court below has taken cognizance, it is a case of this 76cc.
If you are reading it regarding the application under 205.
205.
But he is now questioning the entire proceeding.
This pair is like this. They have read that the 2cc filed by the Department of Income Tax will go away.
They are challenging.
Yes, enter person they are challenging, and they are fair, alternate fair is that.
The question of law is the prosecution launched by you.
Yes.
276 double C, 1976.
It is not read out that they should be qualified.
In view of the fact that the assessment order pertaining that financial order has already been aside, and it went up to Supreme Court has upheld that. And penalty order is also penalty proceeding also initiated by you in the absence of quantum of the.
They are coming to clear. Again, I said
that was
they are coming to clear. One order probably SEJ. Another order is the cognizance. This what order I am showing there is first was the complaint case of
205 is allowed.
Yes.
They are not happy with that.
Yes. That's right.
If they are happy, I will allow right now.
That's right.
If the 205 is allowed.
For faster.
Yes, sir. 205 is allowed.
No,
if we have it.
Can you look at the complaint for the criminal?
they are attacking the entire company. Yes, they're pretty logical. See, initiation of a criminal complaint, 205, one can allow, no problem.
Well, what you may see on page 43. What is the complaint? Let us see what is the basis of the complaint.
The document is not with us, so that's why I don't want to. This, because the complaint petition they have given, yes, a lot of documents are there. Lot of they page 51, documents relied upon. There's a lot of documents, there are about 12 documents are there. It is not available with them. We'll get it, no issue. From the department itself.
The whole complaint petition, my lord, paragraph 6 onwards, is they at page 46, is based on the assessment order. The assessment order, various disallowances, additions are made on the issue of suppression of sale, receipts outside the books of account, inflation of raising expenses, and cash receipts and so from the assessing form had suppressed. And that after the table, at the time of search, the assessing putting all the information, documents, and so and so, so and so. There is no reason why records information so and so. We'll actually kindly turn over the page. We'll actually see page 47. What is 276C1? My lord, if a person willfully attempts in any manner to evade tax, penalty, or interest chargeable or imposable under this act, he shall, without prejudice to any penalty that may be imposed upon him under any of the provisions of this act, be punishable. So therefore, what are the preconditions? I have evaded tax. I have evaded penalty or interest. Today, after the Supreme Court judgment, there is no evasion of tax. There is no evasion of penalty. So, on the contrary, I have to get refunds. So, how are the ingredients of 276C1 even present in this? That's the short point.
Yes, Mr. Body, paragraph 5, page 45. Yes. That the notice was issued to many partners as well as to the partners of the firm on 13th and 16th 4/2015 to show cause as to why the prosecution should not be initiated against them. Person is 276 C subclause 1 and the 276 CC of the Income Tax Act 61. There has been no complaint by SSC. Further, the SSC and all the partners have given due opportunity by focus notice dated 14/11/2014 and second and third December 2014, asking them to show cause why the prosecution proceeding shall not be initiated, but the SSC and the partner of the firm did not submit any explanation within the time. It is not a case that department is initiating the proceeding. Voluntarily, the department is given show cause and then the opportunity is given to public also. They will file a response for this. We have first time it was different. Today it was different for first time. I am issuing notice saying
Lordship, please.
issue notice. Day of the further proceeding and I can see case number.
The Lordship fix a date for hearing of the entire matter.
2 CC case number 18 of. The other matter.
Kali as sir. Whenever Mr. Padi wants, but let us finish.
Kali tomorrow it matter will be initiated, but let's give some more time. For all the matters, let us.
My lord, expert study. What my lord is saying, that let all the matters come tomorrow.
Tomorrow, yes. No, let this letter go. Yes. Page further property, these tomorrow.
I'm good.
And then article will pick a date and fill.
43 also say.
43 also. Yes. 44. Pass also. Yes. 45.
Yes.
Yes.
Petitioner released on bail on 28/3/2006 and NBW was issued on 18/5/2017.
Speak louder.
Petitioner released on bail on 28/3/2006 and NBW was issued on 18/5/2017.
Give 1,000. 5. 30th. Right? So 30th. Okay, next.
45. 45. Yes, 45. My lord.
Well, this case, well, in file challenging the order taking convenience passed by the magistrate in taking convenience for the offence punishable under section 306 by 34 of the Indian Penal Code. Well, I kindly see the FOI. At page 12. In the reading of the FIR matter, at least to my view, no case is put out for the offence under section 306. As it is, but without adding, without subtracting anything. Ballot mechanism. Lexica ଜଣାଇବାର କାରଣ ଏଇଠି ଯେ ମୁଁ ସୁଦାମ ବେହେରା ପେଜ 12 ମୁଁ ଏକ ଛୋଟ ଚାଷୀ ଅଟେ ମୁଁ ଏକ ଛୋଟ ଚାଷୀ ଅଟେ ମୋର ଘରୋଇ ଖର୍ଚ୍ଚ ତଥା ଋଣ ପରିଶୋଧ ପାଇଁ ଟଙ୍କା ଦରକାର ହେବାରୁ ମୁଁ ମୋର ଭାଗପ୍ରାପ୍ତ ଖୁଜିଆନ ବିଭାଗ ବାହାର ପାଣି 2 ଏକର 50 ଜମିକୁ so ହରିହର ବେହେରା ପିତା କୃଷ୍ଣଚନ୍ଦ୍ର ବେହେରା ଠାରେ ଜମି ବନ୍ଧକ ରଖି 2 ଲକ୍ଷ ଟଙ୍କା ଆଣିଥିଲି ଆମର ଜମି ଇସ୍ରାଏଲ ଜମି ଅଟେ ଉକ୍ତ ବନ୍ଧକ ଜମିକୁ ସେମାନେ ବାକି ଟଙ୍କା ଦେଇ ନିଜ ନାମରେ ରେଜିଷ୍ଟ୍ରି କରିଦେବା ପରେ ମୋର ମୃତ ପୁଅ ହରିହର ବେହେରା ଓ ତାଙ୍କ 2 ପୁଅ ଲକ୍ଷ୍ମଣ ବେହେରା ଓ ନାରାୟଣ ବେହେରା ନାରାୟଣ ବେହେରା ବିଷୟ ଅନେକ ଦିନରୁ ଚାପ ପକାଉଥିଲେ ସେମାନେ ମୋର ପୁଅକୁ କାମ କର ଓ ଆମ ନେଇଥିବା ସମସ୍ତ ଟଙ୍କା ସୁଝି ଦିଅ ନହେଲେ ତୁମ ଜମିକୁ ଆମକୁ ରେଜିଷ୍ଟ୍ରି କରିଦିଅ ବୋଲି ବାରମ୍ବାର କହି ଅସଭ୍ୟ ଭାଷାରେ ଗାଳିଗୁଲଜ କରୁଥିଲେ ଘଟଣା ପୂର୍ବରୁ ପ୍ରାୟ 6 ମାସ ହେବ ସେ ଏଇ କଥା ତା ମାଆଙ୍କୁ କହିଥିଲେ ପରେ ମୁଁ ହରିହର ବେହେରାକୁ ଭେଟି ମୋର ପୁଅକୁ କିଛି କଥା ନ କହିବାକୁ ମନା କରିଥିଲି କିନ୍ତୁ ସେମାନେ ମାନି ନଥିଲେ ଏବଂ ସେମାନେ ମୋର ଏକମାତ୍ର ପୁଅକୁ ମାନସିକ ଚାପ ପକାଇଥିଲେ ଶେଷରେ ଗତ 13/2/2023 ରାତ୍ର 7 ଘଣ୍ଟା ସମୟରେ ମୋ ପୁଅ ସେମାନଙ୍କ କଟୁ କଥାକୁ ସହି ନପାରି ବିଷ ପିଇଲେ ହେଲେ ସେ ବିଷ ପିଇବା କଥା ଆମେ ସଙ୍ଗେ ସାଙ୍ଗେ ଜାଣିପାରିଲୁ ନାହିଁ ଆମେ ତା ପରଦିନ ତା ଦେହ ଖରାପ ହେବାରୁ ତାକୁ କ'ଣ ହେଲା ବୋଲି ପଚାରିବାରୁ ହରିହର ବେହେରା ଓ ତାଙ୍କ ପୁଅମାନେ ବାରମ୍ବାର ମୋତେ ଜମିକୁ ନେଇ ମାନସିକ ଚାପ ଦେଉଥିବାରୁ ମୁଁ ସହି ନପାରି ବିଷ ପିଇ ଦେଇଛି ବୋଲି କହିଲି
Very kind of time.
Yes, maybe the statement of the deceased, but the spread of the apex score is otherwise. Even if I will say that go and commit suicide in a case of rape and murder.
What the final form says?
Final form says like that. This is the case, entire case of the prosecution. ମୋର ଠୁ ଟଙ୍କା ନେଲା ମୁଁ ତାକୁ କହିଲି ତମେ ଯଦି ଟଙ୍କା ନ ଦେଇ ପାରୁଛ ସେ କାମ କରିକି ମାନସିକ ଚାପରେ କ'ଣ ଜଣେ ମାନସିକ ଚାପ ମାନେ we are pressing hard to our careers to do this, prepare it by overnight. So चाପରେ যদি next day visit करको responsible. Anything can be done by anyone.
Don't know, somebody may be very emotional, somebody may be sick, nothing happens to him.
Well, let me see the charges. I have annexed the charges.
Yeah.
Correct. Yes, certified. Investigation and supervision disclosed that the complainant in the permanent residence of complainant Sibo Sankar is a small farmer and maintaining his family by doing labor work and cultivation. He blessed with only son named Mrs. Hon'Ble and 3 daughters. 2 daughters are married and so on for himself. He has taken loan of 2 lakhs.
Your lordship said directly into surrender and approach the loan.
That is with regards to bail.
He has not approached. That is my only submission with regards to the IE. Because there's an IE for no person. He has not approached. Even the anticipated bail application has been rejected. And your lordship's there, and the ABL appeal also had time.
By that, yes, he kept the specification specifying the area implied that to dispose of for the next activity.
Finally, bring the diary, let us see. If any material is there, it's all right or well? Because there are judgments, many judgments there are. The whole litigation. If there are, how many witnesses you have examined? If there are
I will also prepare a short court.
So what are the materials? If some material is there, he has to.
Yes, I'm quite conscious that I'm moving an application for 480 that for quasi.
Passing at this stage,
At this stage,
by accepting the prosecution story as it is, whether can you maintain?
Without that you like doing.
Your Lordship is fixing it.
Fix it. First thing,
Seven.
come with judgment. Yes. 47.
47, may I please, Your Lordship? My Lord, Belgium matter.
Yes.
NBW issued on 27/5/2022. Earlier, he was on bail by order dated 3/8/2013, my Lord.
27/5/2022. And you will see the file. Don't do it. Put it out of the
Any part, I told you for 82. I am for the petitioner. My lawyer friend is for the opposite party. Thank you.
Next.
48. He was released on bail by the Leonard Court on 22/2017. Subsequently, NBW has been issued on 11th September 2023. That is page number 15.
It is granted bail on 22/8/2000. NBW have issued on 15/10/2019.
Okay.
50. NBW issued on 22/11/22, bail on 23rd March 2018.
18.
29 March 2018.
This is item 49. 51. 50. Okay.
2% 5.2.
2% 500. Yes.
But I am permitted to correct the additional session, those assessment session.
Correct. Next.
51. My lord. NBW is on 31/5/23. Bail order 6/9/2022.
22.
My lord.
NBW is 31/5/23.
My lord, correct the name of the court.
Huh?
Name of the court, correct the name of the court.
Name of the
Court. Assistant son the artist.
give it to counter sign. Yes.
Bail was granted on 15/11/2011. NBW is note 2024.
25.
Okay.
Please allow something. Here, my Lord, the petitioner challenging the order of NBW. Here, the matter is a little different, my Lord.
No.
Initially,
You were on bail or
not bail. But your Lordship kindly consider that FIR section is 294/406/506 of IPC, but what Hon'Ble Apex Court passed in Satyendra Kumar until in both the decisions, my Lord.
go and tell all the things in the court.
No, my Lord, your Lordship,
I'm keeping it a bench and I'm
just consider one paragraph. Your Lordship.
What in NBW, what will I do?
Your Lordship, I'm going to. The court.
What do you want? You want passing of NBW?
Yes, my Lord.
I'm passing it and you want appear.
My Lord, but some observation is required, my Lord, such type of practice are going in the learned court below, your Lordship. Kindly consider one paragraph, only one paragraph. The court will have to satisfy, my Lord, the court will have to satisfy themselves on the compliance of 41A and 41 and 41A of the CRPC. Any non-compliance will entitle the accused for grant of bail. Here, this case, my Lord, the offense is 406/506.
That's right. All this.
But the IO trade NBW against the petitioners. How the court passed NBW order, my Lord? When there is a specific direction.
Why and how the courts are passing the order? I do.
Your Lordship, next paragraph, Honorable Supreme Court also observed, is pleased that magistrates are passing custody orders and this order in violation of the direction previous order. It is duty of the High Court that it ensures that the
judiciary under the provision follow the law of the land. If such orders are being passed by some magistrate, it may even require some judicial work to be withdrawn and the magistrate to be sent to judicial academy for upgradation of the skill, my lord. 41 is.
See who appeared in it.
Hello?
You see who appeared in it.
Yes, my lord. But my lord, sir, your lordship may kindly observe this case also.
I just, okay. The petitioner is challenging the order dated 26/6/2018, whereby NBW has been issued against the petitioner. Mr. Sahu and counsel for the petitioner submits that the implead order is passed by the court below without the appreciation of the very judgment of this very judgment of the government Supreme Court, including the judgment passed happened second. So we conclude. Petitioner may raise all the points that is before below, by giving the complete application. The LPW was issued on 26/6/2018 by the Court of HCGM, Kyonchar, in state till 30th. Something to condition with the PNE of the court below and move the application under law. Under law. I've written that something that is written. Yes.
My lord, the offenses were applicable under 41. Magistrates are passing this order, my lord, without considering the.
Who appropriate application, pleading all this.
Yes, yes.
So that any order comes, then comes to 488.
Great, my lord. Great.
Yes. 54. 27/2023, well order 28/9/22.
May I please your lordship?
Yes.
May I please. 7/7/2023 and NBW order dated 19/3/2024.
Yes, enough. Yes.
56.
Chief Belgium, yes, NBW issued on 26/10/2023, 13. Of petitioner and others were released on 2/4/2024.
NBW 1,000.
57.
Mr. Manku, Lordship, NBW was issued on 28/3/2024 and petitioner was released on the 23/2/2024.
You got bail when?
Then it's 23rd/2/2024.
58.
Belgium national petitioner initially listed payment 18/5/2012. Thereafter, my lord, NBW issued on
30th.
11/12/16. Subsequently, my lord, remainder NBW issued on 30th/2018.
Subsequently on 30th, April, ठीक है, 1,000.
59. It has already been granted only modification of a condition. It shall appear before the IO once in a fortnight. He stays in native balance. Once in a fortnight means.
Where is the condition?
Well, at running page 12. It shall appear, and it's not main accused. The main accused, all have been released. Well, so the only allegation against him is he went accompanying the main accused to a particular plot which has been sold. There is some my lords, for in that selling of that plot, he has not either received They have also been granted bail by your lordships without any condition. Only thing is 15 days is, he will appear through VC if your lordship says.
Yes, in Delhi.
I don't know when you got him back.
That.
And also it got appear from this.
The petitioner had been admitted to bail on 7/3/2024 by the Court of Special Judge CBI Bhubaneswar. Bhubaneswar. They agreed by the condition that we shall appear before the IO in a fortnight till the completion of the investigation. Mr. Waiting for the petition, that's the petitioner is the resident of Delhi and appearing every fortnight before the IO is difficult in part. However, we undertake that in advance. If the IO requires such presence, we shall be appearing before the IO and appearing before the IO, either personally or through video conference. With the
Yes. Well, the IO summary and notice at least 15 days before, because it's getting tight pockets and other things.
Whenever the IO requires the presence of the petitioner, he shall issue notice to advance notice to the petitioner. He can so that the petitioner can come and appear before the
Yes.
advance notice is now tickets are very costly.
Sometimes it's very difficult to get them.
Vistara is getting attention with 30. In this sector, it is very difficult.
I'll give them the WhatsApp number also. WhatsApp and 61.
And then excuse me, there is a body dispensing with 35 to that I have already got. I have a kind of video.
What do you want?
Never have tried.
I have dispense with this appointment. They have time appointment.
That never happened.
Yes. The IA number sounds go. Taking dispensation of different to file that their copy is allowed. Allowed. And we have file that copy of the number which will take it.
62.
Please, Your Lordship. Item 62, I may be permitted to appear through his.
Yes, yes.
62.
Yes,
62, Your Lordship.
Yes, sir. What do you want?
I am situated to my door.
Yes, Your Lordship. So this.
But he is appealing. Yes, what do you want now, Mr. Saab?
This is an application to.
He will solve the copy.
62. 63.
63.
That's 60.
Okay, 62 years.
Yeah.
You have not solved the copy on the opposite side.
I will solve the copy and remove the defects in the meantime.
Yes, you remove the different printing.
Oblige.
Undertakes to serve the copy of the petition to the Mr. and cure the defects is the matter. 63? Yes, 63. Yes, sir.
I did not like. I am forward to find the press records.
Notice was issued to the department number 3. Service is incomplete. Each step press the service.
64.
The same day, same incident 2 years ago. That should indicate order dated 6/2/2024. 6/2/2024.
Yes.
Yes, ma'am. 2 years I asked. The one item is, well, the first FIR is the 1159/2023, and second one is the 1166. This is second.
The incident happened on from preferential. Maybe by information. Yes, yes.
This matter will take along with the I don't know 80.
80.
Both matters are both matters.
There will 2 FIRs, 2 FIR charges.
It's really correct.
My lord, I think
Yes, Lord. One is house owner, one is tenant. He said it. I'll leave it to her. If both cases will be tagged together, my lord, and one trial will be better.
Oh, no. Yes.
These persons are interested in that case, my lord. But the lordship that both the cases, my lord, and send back to the
lordship that one case, notice has been issued. Actually, notice has been issued, but the opposite party is not unknown.
What is the issue? Can it be settled?
So, lordship, the second one, in my offenses cannot be one is
195
one is house owner, one is tenant.
So, will they come with the
I have got the information on the IO, my lord. And not already, my lord, left that area, my lord. That area is my lord. It will be better, my lord, both cases will tag together, my lord, one trial.
Lordship is only one.
But it isn't great. But both
otherwise, idea was because 354 is there. That lady will come who will.
So ladies, notice has the issue. Police has asked. Lordship is notice has the registration post. Then again, you know, lordship directed to police not the notice. Police has gone. And I'm a senior citizen. The lady is not there. That means
What about item 18?
It was type 18. It is a landlord. He is the tenant.
see the last time the my lord answer before he expected to appear before this
Inspector.
Advocate Mr. Mishra.
65.
I'm Bishop Puri, my lord. I may be granted a 1 week time to remove all the defects, my lord.
1 week time can remove the base. Yes, ma'am.
It's what's going to be displayed with the very special because under there is a directions for a disposal equipment. Within the stipulated time period. Perhaps let's ask for the special judges ask for time for extension time.
What was the recently the problem.
Special judges ask for time will also allow some time. At the last time.
99 is.
That earlier occasion that asylum going to time for them for you. You can still then
99, FIR is 99. And the magistrate, special judge, vigilance, is saying that you are not examining anyone. I don't know. Yes. It is apt to mention here that till date, the prosecution failed to examine a single witness in this case.
And
out of 34 charge.
allow some time. So that's some I also instruct the Department of Procurement, attendance of the witnesses or the applicant orders will be passed on.
How much I left in? 3 months early time was one.
The maximum date of declaration.
99. So,
Yes, yes, yes.
after 3 months. But I,
At last.
it is not taken.
Possibly not or not, then lots of other that will be.
By daughter date, by council date. The daughter date 11/1/2024. Transport and directed to the High Court. Right. Within 3 months. Keeping in view to the fact that the reasons we have pertaining to an FIR up to 1990. In process of the appointment order in the special judge, while the application date 8/4/2024. 6/4/2024. But for in the same letter, the official and we have mentioned that the south of the has not taken any step even to examine a single witness. Although there are 34 classified witnesses again by the prosecution. It seems the prosecution is not taking very good step to conclude the trial. Prosecution that he that the prosecution seems to see that all the witnesses are examined, all the necessary witnesses are examined, so that the back of me taking the request made by the special but and this is made by Hon'Ble and the so another 4 months. 1 month ADT to the 67. It's what which language? Included one. Which is 67. Yes, which discuss some side. I can tell you. Research is something that's observed. Now, nobody because it was my kind of thing first place. It's not correctly from me. Correctly, I want to reason for you. The include of the it's a matter of technology. Never why you took the entry model now you are coming at them. See, you took the entry model on 11/1/24. Thereafter, metric came up on 30th January 24. Thereafter, 13/2/24. Again, 22/3/24. Again, you have nothing. Yes. 1, 2, 3, 4. I'll look at the entry model. That's the reason I'm not giving it. You tell me how to go. By the order dated 11/1/2024, notice to the order and interim order. Thereafter, the matter was registered on 30th January 24, 13/1/2024, and 22/3/2024. All matter was adjourned at the request of the petitioner. When the call of the we also like to operate like in the present case. While we have the last opportunity, we have to on the big data, we not I'll do the entry model stands automatically. 68. This is 5%. GRS was 231 up to 2023 corresponding to this is not 215. 13 of 2023. Under social. 420. What do you want? I want to put because ingredients are not satisfied. 420. 93 pages. Now the FIR is investigation is going on. 17. That's 17. But the investigation is still going on. No score of cheating. The investigation is still going on. Now FIR is only filed. How do you know it is made out or not? I think it was liquid. No. Not allowed. First of 420. It's a private citizen. Yes, 420. No, only FIR is law. And in this petition, except FIR, you have not filed anything. Not a stretch of paper. FIR, thereafter, you are a Wakalatnama. You want that to be passed on this stage. How is it possible to tell me? Supreme Court says that. Supreme Court doesn't say that you don't file anything and complaint. If the offense is what Supreme Court says, that without filing any document, immediately the FIR is lost. You got to the court and ask for passing. The judgment. Yes. Yes. What is the read the plan. Yes. If it's an Abhipraya, Merun Nisha, Swami 6 Imam. This is board or GP, yes, plus red, registered numbers 1, 2, if a Chukki Namare, Nano Chandro, with the Ramanaran Chandro, Anna Dilla, date later. Chukki was a guide of Marseto, bank, you know, Haru Aranga for it, some of the personal Palapore, Polishur of City, 40 Masan. Into Pari Dematin, under Constitution. They will not be carried to the other allegations may be correct. Police has registered under section 420. 420. There is no. There it is registration. After investigation, they may drop 420 also. They may file a closing also. All the things you don't tell the police. How can I examine? Am I investigating officer? And how can I do it? Maybe you are correct 100%. Nothing is in it. But it's still investigation is going on. You have to go and tell the police all the time. So you withdraw this and go and tell all the police. You have maybe you are correct. If there was an agreement, and on the basis of agreement, you are supposed to give the installment. You will not. When he is asking for installment, you are holding in and that's the thing.
Actually, 420 may not be made out. What you are threatening? You are saying that I'll burn the vehicle. In some case, in some offenses may be given out. We don't know. So therefore, you go on. Reserving right to approach the court or need to survive the protection to that I have filed anticipating bail order already there. Am I sitting and appeal over that order? Then if it would not have gone, then perhaps we might have issued 41 units. You are burning a failure. Makes sense. 70. Yes. Extension of time. How much time I had given? How much time? My lord, this order. How much time they want? 1 month. That is good. This application extension of right granted currently 24. By 15 to 20. Taking into consideration the application is allowed. It is directed to surrender reporting code below on or before 30th of May 2024 and seek remedy available to.
My lord, your lordship, though we have also released on bail by after languishing jail custody, your lordship may surrender and released on bail. Belgium matter, my lord.
Belgium, therefore, I have already said what.
My lord, there is a 436 and other 395 is accession travel upon the.
Won't tell all this thing. I have extended time. Yes. Next.
71.
My lord. In this case, compromise is going on. Second week of May.
Submits that there is a possibility of out of court settlement, which is going on at this stage. Therefore, he seeks an adjournment. I have today I pronounce a judgment. Just see if it can come to your benefit.
Today. 72.
72, my lord, kindly pass over. Pass over, my lord.
Pass.
73.
73. Yes, may I please. Here, my lord, for modification of order, your lordship's order.
Modification of which order?
I've annexed, my lord.
Yes.
Is in CRLMC number 406 of 2024.
No. What is the mistake?
My lord has directed to kept advance of the NBW and direction was issued to surrender before the court below on 7/3/2024. My humble submission, my lord, since the case is committed to the Court of Sessions, my lord, it is difficult for the petitioner to surrender before the magistrate, my lord.
You want to surrender before Sessions Court?
Lordship, first hour, second hour, so that he will have.
NBW, I will not do that. NBW, I pass a
then
common order.
It is already committed, so lordship may direct.
See, where is the application? Application lekho. So seeks modification of the order dated 19/2/2024. He submits that by the time this the order dated 19/2/2024 was passed, the case was already committed to which court?
Court of Sessions, my lord.
Court of Session. Give the particulars.
My lord.
Court of Session, which court? Give the particulars of the court. How you are asking for modification? You don't know the particulars of the court. Adjourn it tomorrow. Come tomorrow. Exact particular of the court I have to mention in the order. And the case.
Session, court of
Session. Don't see. Again, you will move application for modification. Friday. Yes.
74.
My lord, kindly pass over. It is a
Pass.
compromised case, but both parties are present. The
Okay.
compromise affidavit is going on. Bless.
Yes.
75.
Please, ma'am. Extension of time, my lord. Order dated 13/3/24. Date was fixed for surrender of 5/4/24, my lord.
5/4/24 को extend करूँगी 30th में April को.
मतलब कोर्ट नाटा
हाँ?
तଳ कोर्ट नाटा भूल अछि एडीजे कम स्पेशल जज पोक्सो ब्रैकेट रे एफटीएसएससी ऑन गोल्ड.
What you had written?
एफटीसीएस टा लिखि नथिले फास्ट ट्रैक स्पेशल
कौन करियो कौन अपन जहाँ लिखिते से हिसाब कराई छी ना.
करेक्शन एडीजे कम स्पेशल जज पोक्सो एफटीएससी ऑन गोल्ड. प्रेयर आई हैव मेड.
सीधे करेक्शन कर दो. ठीक है. डेट एक्सटेंड कर दियो फिर इस पे और ठीक लिख के दियो.
यस मैडम, यस
कोड भी modified, huh?
76.
My lord, this is an application for modification. In the order passed by this honorable court, it is reflected inadvertently in paragraph 5 that the date of order for issuance of NBW passed by the Sessions Court
is 28/10/2019
instead of 21/6/2023. The correct one is, error is 28/10/2019, correction is 21/6/2023.
नहीं. Sorry. Another see. What? And what? Fresh matter? Any fresh matter?
No, fresh completed.
By the petitioner, they have also returned the amount. But this is the case. My lord, I am coming to the FIR, my lord. Simply, I am coming to the FIR, and what is the allegation persons have been cited in the FIR, my lord. Out of them, the one of the BDO who was the predecessor of the present petitioner, who had sanctioned the 185 beneficiaries, he is no more. And other 7 accused persons, one of myself is one, and other 6 persons, they are the VLWs. Out of them, all of them have been retired on superannuation.
We don't know if any accused has gone to the court to ask for a stay.
No, there is no stay at all. There is no stay.
Is that so far as allegation is concerned, without initiating any file, if we have seized the file, in file there is no noting, only question mark is there, and money was disbursed in favor of sanction. All the money, the money sanction that was cancelled. The plan project was cancelled, and thereafter he issued notice to deposit. And eligible persons are concerned. The charge sheet within 2 months you are allowed to.
That point, my lord, I have been harassed for last 11 years. What is the wrong I have committed, my lord? Whether I have
misappropriated what wrong you have committed,
my lord. As for the face value of the FIR itself shows that I have never
and committed suicide, my lords. And that too, the FIR
even
is.
if it would have come, it would have come to his brother only.
Yes, my lords. And the FIR is lodged 7 months thereafter. And there is no direct nexus, my lords.
Yes, my lord. First of all, my
What
lord,
is this?
the FIR was registered under 306 million. And thereafter, my lord, final report was submitted as the mistake of a fact. And again, thereafter, the petitioner came to here with the protest petition, my lord. And the cog has taken, my lord. So,
where is the question? See, the allegations are very weird allegations.
Yes, my lord.
Who is appearing for the opposition? What kind of allegation?
A statement was recorded by the Lord Magistrate, my lord.
Maybe just see what are the allegation. Allegation is your brother was supposed to get some money from the company.
Yes, ma'am.
Because he did not get the money, therefore you have gone in depression. That's the reason you are prosecuting the company people, that you have not paid the money.
He has not paid by the company. The brother committed suicide, my lord, without.
How will you relate it? Brother suicide with the money supposed to be received by your brother?
Both brothers, my lord. The petitioner and the who deceased, my lord, both are brothers. They are working under the said company, my lord. They have taken the work, my lord, and they have done the work. Thereafter, time and again, my lord, while he has approached the company, my lord, they have not paid. They have torture like anything, my lord.
What is torture? What kind of torture?
Your lordship, kindly see the deposition
If this story is believed, then all the contractors in those who are working for government
let them
will commit suicide.
let
Their
them,
money is never paid.
they have not
They have to
paid
pay
a single
percentage to
pie,
get the
my
money, contractors. Everybody will commit suicide then.
lord.
And
That
all
is
will-
the fact, my lord.
What? Where is the statement?
Statement.
Initial statement, he says, I am the proprietor, the brother who lodges the FIR. That is at running page 34. Additional affidavit I've given.
Yes.
Running page Uday Dora. I am the proprietor of Dora Constructions and I have taken a project work. He takes the project work by Afcon's infrastructure.
The brother says.
The brother. Jammu and Kashmir. This is.
I'm the proprietor of Dora Construction.
I am the
I have
proprietor
taken
of,
project work.
and I have taken a project work by Afcon's Infrastructure Limited, Jammu and Kashmir, Khadi Tahsil in the year 2000. I used to work for said Afcon's company till 2020, but in the middle of the year.
Who are you in the company?
Who? My lords.
You.
We, my lords, one is the general manager and one is an assistant manager. These.
What is the specific allegation against you?
No specific allegation. Your lordship sees the entire initial statement. I am a proprietor of Dora. I have taken a project work. I used to work for Afcons till 2020, but in the middle of year 2020, due to COVID issues, I have stopped my work for them. My brother, late Sanjay Dora, was also working for said Afcons in the as in charge foreman for his Dora construction. I have authorized my late brother to take care.
Absolutely.
He has not paid a single pie, my lord.
Maybe it is a matter of because 306. How will you attract 306?
Well, due to torture, my lord, the brother committed suicide, my lord.
What is the torture you show me in from the entire allegation? In 202 statement. Unfortunately, this boy might have died, and you are trying to use this occasion to extract money.
No, my lord.
This is what is the fact is. What is this? Read it. Para 6. My brother late Sanjay Dora.
Have made the company personal manager.
Company personals.
Yes, ma'am.
Namely Ravindra. This is petitioner.
Ravindra Singh Chauhan,
AGM,
namely
and
Chandrasekhar Dikshit.
And gave them a copy of email and letter sent by me personally.
But
they did not respond and take any step. Instead, they have only harassed my late brother, for which he returned to the village. What is harassment? What is harassment?
Harassment, they have not paid a single pie, my lord. That is the harassment, my lord, due to COVID, my lord. He has not paid the amount, my lord. He did not repay the same to the labor, my lord. Due to torture, my lord, he committed suicide, my lord. Thereafter, my lord, as the company personnel have not cleared the dues.
He committed suicide on 22/8/2021.
Yes, my lord.
Immediately before that, what had happened? You don't give the date when he has gone to Kashmir with the letter and email. What is the provocation?
That is the subject matter of trial, my lord.
No.
The evidence was taken, my lord, 202 inquiry, and cognizance was taken, my lord.
It's very, very beautiful.
Let them face the trial, my lord. Fix a target that will be end, my lord.
I'm taking the statement as it is. Then I find there is no case.
Due to torture, my lord, one life has gone, my lord.
Maybe saying torture will not make torture, sir.
Lordship, keep it.
You say only harass.
Next week, I will specifically show what is the torture, my lord.
Friday come with the judgment. If you can support judgment, it will.
Yes,
see,
sir.
final. The police investigated, filed the final charge.
Yes.
Then you filed the protest petition, and you made this statement. Except saying that my brother was harassed.
Your lordship, keep it to
Because
29th or 30th, my lord.
29. 30th.
Yes.
On the request of the respondent, the matter is adjourned, not to 30th. It is made clear that no further adjournments shall be granted.
Yes.
Okay.
Interim order.
Some judgment if you can support.
Interim order.
Interim order to continue.
In fact, there are judgments in our favor. The number of 3 judgments and
By the way, why don't you pay? At least this is arm twisting method because unfortunately brother died.
Yes,
He has foisted this case against you only to get the money. Pay the money. Finish it.
The problem is we are not the directors of the company, and the company itself, they have to pay money to the
How much?
company.
How much?
I don't know
How
exactly.
much I
Malad.
give to you? What is the amount due?
Amount 60 to 70 lakhs, my lord. They have to pay me.
They are, my lords, as per my
You work for a term, my lord.
You file some cheating case, some recovery proceeding, not 306 against.
ଜାମ୍ମୁ କାଶ୍ମୀରରେ ସେ କାମ କଲେ କଲା ପରେ ଆଜ୍ଞା
କିଏ
ଯୋଉ
କଲା?
କୋଭିଡ ପିରିୟଡ
Brother
ଡିଷ୍ଟର୍ବ ହେଇଗଲା
Brother kala na. COVID period to everybody suffered. Brother kala for
ସେଇ ଯୋଉ ଆଜ୍ଞା ଦଉନାହାନ୍ତି
for any reason ପଇସା ଦେଇନାହାନ୍ତି ତାର ଅର୍ଥ ନାହିଁ 306 ଲଗେଇଲେ।
ସେଇ ଟର୍ଚର ଆସିଲା ସେ ସୁସାଇଡ କରିଦେଲା ଆଜ୍ଞା
ଆପଣ ଦେଖନ୍ତୁ କିଛି ପଇସା ଦେବେ।
ମୁଁ ଆଜ୍ଞା company ର ପଇସା ଥିଲେ what as per we have they had talked with the company official, they say we have nothing to pay, this is just an arm twisting method to extract money from us. 7 ମାସ ହେଲା ନହେଲେ ଆଜ୍ଞା ସୁଇସାଇଡ କମିଟ କଲା ସାଙ୍ଗେ ସାଙ୍ଗେ ଏଫଆଇଆର ଦେଇଥାନ୍ତା ନା। ଆଉ 7 ମାସ ୱେଟ କରୁଥିଲେ କାହିଁକି? then suddenly they realize ଯେ ପଇସା ମିଳୁନି।
You think over.
No amount of money can heal her wounds. So she wants to pursue the litigation. I also tried my best.
Sir, choice what to do. See, the problem is 6 years she has already wasted.
And she says that
and another
she's
1 decade or 2 decades. She should have realized that she is at the beginning of the litigation. Anyway, we made our efforts. Yes.
Then in that case, the present matter, which is listed, be listed to some other.
Item.
It is item 83.
83.
On merit, can we fix to any date?
Yes, yes. Interim order to continue, list the matter.
List the matter.
The settlement, shall I record it?
No, you have not recorded, but only recorded in-house camera hearing. So that's not describing.
Even recorded.
Okay, we'll list it for final disposal.
Can it be up to 3-4 weeks?
Yes, yes.
After vacation.
After vacation. After vacation, but bench change ମୁଁ already 3 दिन କାମ ସାରିଛି ପୁଣି ଆଉ
Lordship may have it.
Second week.
Second backed up.
Second week of May.
Third week.
14th.
Just before vacation bench.
You can keep it on 20th, 20, 20 and 21st. 20, yes.
21st, there will be half
20th.
17, 16, 17, madam?
16, 17.
16.
Item 85, my lord. After
which one?
85.
85.
My lord.
After notice or face?
No, it after notice step है किछ नहीं. Document.
Yes, opposite side actually.
State.
May I be pardoned to make a mention, Milords? Item 67, Milords. My associate was appearing. And Milords, the interim order has been vacated because...
not vacated. I am not vacated.
Item 67, Milords.
No, I have said that next time if you don't come, then it will automatically vacate.
I apologize.
I have not vacated. I have not vacated. I have said that repeatedly petitioner is seeking time. And this time it is adjourned. But next time if you ask, then it will be automatically.
I'm grateful. Milords, it has been adjourned because the OP2 has not appeared despite...
Whatever, next time you tell, I am not vacated.
I'm grateful. Milords, posted it to after.
Given it.
Item 9.
I'm grateful.
Item 9, I may permitted, my lords.
Yes.
My lords, the matter relates to 138 enact proceeding, my lords, in which I am the accused.
Who is appearing?
I am appearing for the opposite.
Yes.
Lordship. My lords, on
you are the accused.
I am the accused, my lords.
Yes.
So I filed an application for recall of witness number 1, PW1 for further cross-examination, but that was rejected. And my questionnaire is as page.
I've seen the questionnaire. What is
No, well, I have not been supplied any copy of that petition. I mean, that is not available. A copy may be supplied.
You have not supplied the copy to the opposite side?
My brother has appeared so moto, so no notice as per
Okay.
my knowledge. So I will supply him.
Right now. Mr. Rathore appearing for the opposite party submits that copy of the petition has not been supplied to him. Mr. Raut appearing for the petitioner undertakes to supply the copy for the petition. These the matter also. Give a copy to us. Yes.
Let's say a short date may be fixed kindly.
Yeah, date will be given. Yes.
Item 10.
May I please, Your Lordship?
Yes.
The petition filed this case to quash the proceeding. Both the parties are present today, my lord.
What is the allegation? 307. Have you seen?
Injury simple in nature.
One injury, simple. Head injury, simple injury.
Head injury, simply. Who is the informant? Mandakini Vishwa. What is this you have?
My lord, that para wrongly, my lord. That is the problem.
Previous year.
Because
Copy paste person.
You bring a better one. Change it and what is this? How can it be taken on judicial record? Let's check it up. Can't take it out.
My lord,
Change it.
my lord. Change them.
Change it and come. Immediately I'll take the other
My
matter.
lord.
Yes. Just now you come.
My
Item 11.
Item 11, may I be permitted to withdraw, my lord, for filing better petition?
Withdraw 11. Yes.
Item 13.
Yes.
May I please, Your Lordship?
Yes.
My lord, the moot question before my lord would be that the order taking cognizance, my lord. The order taking cognizance having been made against the non-charge sheeted accused is the subtle point before Lordship, my lord. My lord, the backdrop of the issue is, my lord, that the complainant, the informant purchased a plot that sale deed was executed in her favor.
Muralidhar Sahu is not named in the charge sheet.
Yes, yes, my lord. That is my Muralidhar Sahu, not charge sheeted in the 173(2).
If anything comes, then you have to employ 319.
No, here filed the charge sheet.
No, so that's it. So
Page 27, my lord.
20, let me see.
Where is it? 20?
Page 27, my lord.
Soon is an accused.
Pen 27.
Page 20.
7.
Hey, you are an accused.
That,
Muralidhar Sahu.
my lord, that about
No,
another thing I'm
coming, my lord, charge sheet is submitted, my lord, at page, may invite Lordship's kind attention. My lord, charge sheet is submitted at page, my lord, 67, my lord. May I invite Lordship's kind attention, page 67. This is the charge sheet. And this is the police report, which is commonly and popularly known as charge sheet or challan, has been submitted. Page 67, your
Whether the
lordship.
case is made out against you or not, that's a different story.
Yes. But whether my
The beginning statement was that he was not charge sheeted. That's
Yes.
wrong.
That is
If
my.
he was not charge sheeted, then obviously cognizance can't be taken.
Oh, that is my.
But you have been charge sheeted.
No, not, my lord, may I invite
You
your
are
kind
one of the
attention.
accused.
Page 67, my lord, the police has.
Then you are saying the second question. Whether on the basis of the allegation, no case is made out. That's the second question. But the fact is, charge sheet is filed against you.
But that is my humble submission. Police has not submitted charge sheet against me. Police has submitted charge sheet against 2 persons. That is my inventor's kind attempt.
He is the director of the company.
Lord,
Another
my lord, my
court submission.
my lord, your lordship.
His pre-arrest bail has been rejected by appeals court as is the dishonorable court. Thereafter, he has
Well,
filed
that
this
is
case.
the during investigation. Prior,
He has not arrested
my,
till that.
my humble submission on completion of investigation 173(2), my lord, the police submitted charge sheet made page 67, my lord.
Yes,
Well, kindly have
I'm
it. Glance.
glad.
Kindly have glance, my lord. Page 67. Then what? This is the charge sheet, my lord. Last but 2 line, my lord.
You are a director. You are the director.
Yes, director.
No, I'm one of the directors. But the allegation is against the Nirvikananda and Prafula Dale, against those who have directly transacted the
But
consideration.
they are your employee.
No, they are the managing director. As per the
You
company
are
act,
one of the directors.
one of the as per the company act 220.
ESCON Escon Private Limited is one of the accused.
One of them.
And
That is,
you being a director, you are also.
yes,
making.
yes, yes,
Charge
that,
has been
that
filed.
is, my lord.
Whether a case is made out or not made out, a cognizant stage, I can't go in.
My lord, that police, my lord, as your lordship already viewed, my lord, just before, I down the lordship, that if the charge sheet, the police has not charge sheet, submitted charge sheet against me, the order taking cognizance is bad. Therefore, my lord,
What is that?
the 67 page 67, police submitted charge sheet against 2%, my lord.
No,
Therefore-
that has been mentioned, my lord. Other
No, that
accused person, namely Murlidhar Sahu, present petitioner, and another have been
The realm of investigation. They are in the realm of investigation. Therefore, police are sought for further investigation. Therefore, my lord, if further materials come, there is no inhibition for the police. Inhibition for the police to produce any further document as section 173(8), my lord.
I'm sorry,
Then
my lord.
Yes.
What happened, my lord? During file of charge sheet, my lord, there is a stay order in the bail application, my lord. They clearly mentions that why that is mentioned, my lord. Subsequently, my lord, he has been charge sheeted and his bail has been rejected, my lord. His bail has been rejected. Prior to rejection of that bail, my lord, the charge sheet has been filed.
The charge sheet has been filed on dated. The charge sheet has been, yes, charge sheet has been filed on 23/10/19.
Yes.
And the next day, 24/10/19.
173(8) was kept open because
Yes. Yeah,
there are many investors, those are coming forward day by day.
Therefore,
that is, it is written.
Therefore,
Many investors are standing behind to file the cases against the above noted accused.
Therefore, my lord.
And their number is growing day to day. And therefore, 173(8) is kept open.
It's therefore my humble submission on the date of taking cognizance, that is 24/10/19. What is the named accused person is 2%. Therefore, my lord, if further
Where
material.
are you reading that?
That is the my lord, page 67.
I am there only.
Yes, last person.
Where does it say only 2%?
2%. Nirbikananda.
Where?
As there is prima facie evidence, my lord. As may read lordship, last 4 lines, my lord. As there is prima facie evidence under section such and such and well established against the accused person, namely Nirbikananda, such and such, then, my lord, last line, Professor Kumar Dale. So, what was the material or the person before the London magistrate on 24th, my lord? These 2%. And if further evidence come,
if the police, while filing charge sheet, the narration which is being given, on that basis, cases are not decided. Cases are decided on the basis of the material placed by the police before the court by way of charge sheet. And you know how this is written. Police take money to not to write your name in the narration. But all materials are filed.
I bow down. But I am on the point of law.
Satisfy and
the point of law.
the smart accused pay the money without realizing all materials are filed. But while writing, police write narration, deleting their name.
I pardon. My humble sir, what transpires.
But yeah, therefore I have to go to the material, not the narration of the police.
Then
has the police written a judgment? Is it his judgment?
That is what it transpires.
He executed somebody or discharge somebody?
I must have ventured to go to that aspect.
Therefore, these narrations are neither here
my
nor.
humble submission, what transpires from that police submitted.
Show me 161 statement.
The first time it was accepted, my lord. First time.
Show me some statement of the investors, those who have
Yes.
complained, whether they have taken your name or not.
My
If
lord,
they have
to
taken your
supplement.
name, then you are in.
Yes,
If they have not taken your name,
But supplementary your lordship, lord, only the allegation by the complainant against 2 specific Nirbikananda has received the money, and the other Prafula Dali has assured to blood the issue
you are
erupted.
one of the directors, sir.
Blood issue erupted that the land was rightly transferred to them, only ingress and egress. That the accused, that the 2 persons, these Prafula and the Nirbikananda, they assured that they will provide ingress and
Who is appearing for state?
I'm
Mr. Raghuda? You are appearing. OPID. Show me 161 statements.
Today I listed in, I'll obtain 161 statement.
What are the material? Forget about what police says.
Milord.
In the narration, they may say whatever. They may file all the documents, thereafter they say he is a gentleman. It makes no sense. You have to see the materials.
Yes.
What are the material you have against him?
Milord, I have not CD not
Because the cognizance is taken on the basis of the material
Milord.
placed by the police before the court. So let us see the materials. Let him file the.
Clearly,
Milord, second
time of filing of the charge sheet, Milord, there is not to arrest. Milord. He has filed a pre-arrest bail, Milord.
And during
He
the
clearly
investigation.
mentioned it mentioned. And his bail has been rejected in December 23, my lord.
And he went to Supreme Court.
That also rejected.
That is investigation.
Anyway, that is a different story.
My lord.
If the case is made out, it's all right. If it's
My
not
lord.
made out.
Then my humble servant, then my second part of argument would be, my lord, the entire gamut of material does not fall within the OPDI Act. That is,
The second argument. Let us see what
second part.
Yes.
Okay.
Yes.
This sheet for hearing. The CD called for.
Any
Get the CD. With us.
My lord.
Lordship speaks.
Yes.
Oblige me.
Item 15.
Yes.
My lord, in this application, the petitioner has challenged the order dated 5/1/2024 passed in a miss case under section 457 CRPC, rejecting my application to release the mobile phone on the ground that in the invoice my name has been wrongly noted. My name is Antarjami Guntha, but in the invoice, my lord, have a glance cash receipt that is Authorjami Guntha. That is the wrong.
Antarjami?
Guntha.
Where is that?
Illiterate not must be highly educated.
Where are you reading?
My lord, I have enclosed in page 15, my lord.
Huh?
Page 15, my lord.
Yes.
The cash bill.
Arthurjami Guntha.
Guntha.
This is the
But
invoice.
my lord,
You purchase.
my lord. My name is Antarjami Guntha.
What to do? How will you establish your ownership?
My
This
lord,
is the only document.
my lord, fact remains the salesman must be not highly educated. So Antarjami se likhi parini. This is the background.
Justify କରିପାରିବେ load code manner. Limited back to trial court manner, he justified there manner the identity.
How can they justify karibi to cash bill ta second na I will file an affidavit to that.
Where is the rejection order? Where is the rejection order?
My lord.
Where is the rejection order?
My lord.
Rejection order.
My lord.
Where is that?
Next, my lord. Next page, my lord.
Vehicle को लिखा है
नहीं फिर हम
vehicle लिखा है
देखा भूल दे बापा ना डाक कौन क्या सुन रही हो सर next page 17 at page 17
Yes. Where is it?
my lord last paragraph on perusal of the petition vis-a-vis the record city number 20 appears his mobile phone actually belongs to one Authorjamu Guntha by one cash bill of Venki Mobiles Main Road Padua so and so sales and service center and the model number so and so. So
The IO can go and verify it.
Yes, yes.
IO can verify.
Yes.
The application moved by the petitioner under section 457 CRPC has been rejected by the court by additional sessions Koraput by the impugn order dated 3/1/2024. Inter alia on the ground. Inter alia on the ground that the sale invoice produced by the petitioner, the name reflecting in the sale invoice produced by the petitioner is differently spelled, and then the differently spelled and not matching with the name of the petitioner. Therefore, the application under section 457 CRPC has been rejected, declining to release the mobile phone. Then counsel for the petitioner submits that the name in the invoice is wrongly spelled. Instead of Antarjami
Guntha.
Arthur Jamu. Arthur Jamu. Arthur Jamu has been written. Let the petitioner move a fresh application before the court below under section 457 CRPC, mentioning these facts, and after verification for the authenticity of the invoice, through the IO or the trial court to dispose of the application. To dispose of the application as early as possible. As early as possible. With this observation, the impugn order is set aside and the matter is remanded back to the court of assistant sessions judge for approval.
Item 17.
May I please?
Yes.
That the marriage has been dissolved between petitioners and the opposite party number.
Settle.
Marriage and dissolved by decree of divorce.
Separated.
Separated.
Where are the parties?
Assembly.
Party notice.
Bring the parties.
Notice.
Notice.
OP2, my lord.
To opposite party number 2, returnable non-essential. When counsel of the petitioner submits that marriage between the petitioner and opposite party number 2 has already been dissolved by mutual consent.
By mutual divorce.
By mutual consent, and the parties have settled their dispute. So we issue notice to opposite party number 2. And in the meantime, the proceeding GR case number 1357 of 2013, arising out of the Patpura PS case number 246 of 2013, pending in the court of SDGM Kannada, is stayed till next date. Yes.
Item 18.
Here I have filed this application for quashing of the entire criminal proceeding against the petitioner. On the ground that in the FIR it was alleged against the secretary of the society, whereas the police registered against the president. And
you are the president.
I am the president. So Lordship will kindly turn to page 12.
Yes.
Of the FIR. The sentence is that बापी दिना तुलसीदार संपादिक षडयंत्र करी काहको बिक्री कर देछन्ते. This is the allegation. But the FIR was registered. Your Lordship will kindly turn to page 10.
No, what in charge sheet what happened? Let us see.
Charge sheet, my lord,
What are they?
was submitted against the main accused. Your Lordship will kindly turn to page 38.
You are the
This petitioner has also been charge sheeted.
charge sheet.
नहीं charge sheet
charge
ही नहीं.
Any?
Your Lordship will ना. Your Lordship will कहीं नहीं.
Not charge sheeted.
ना. क्यों? हम तो.
Whether you are charge sheeted or not.
No, because I have not yet been arrested.
Abscond. You are shown abscond.
Page 38, my lord.
Yes.
Under
What are
the
they?
above fact and summary, I submit charge sheet number so and so under section so and
You
so.
are some Tripathi.
Again, from below Tripathi.
Yes.
My lord, no case can be registered against me under section 376. Only thing, my lord, I will be shown as a abettor.
That's right. 120B also.
କିନ୍ତୁ your lordship will kindly see the FIR on which section this case was registered.
No. Now let us see the charge sheet.
No.
What are the allegations?
Charge sheet. First, your lordship will kindly see the FIR, my lord. FIR ମୋ against କିଛି allegation ନାହିଁ.
Investigation is open.
Yes.
It is against the secretary. But the police has registered the case against me. Serial number 3. President Ruthana. Serial number 3, my lord, page 10, your lordship will kindly.
Yes, I am there.
President. And in that light, my lord, the investigation was proceeded. So far as my involvement in the crime, my lord, nobody has said anything.
What are the charge sheet file under
376N. 376N.
376 2N.
2N. Something to.
Yes. There is no.
And the informant and the accused is present in the court, my lord. The informant says, I have not lodged FIR against you. On that basis, my lord.
No, that part I am not on that. What I am saying is, if it is 376 2N D, you being a woman, how can you rope in unless you say abatement or 120B or something else?
Of course,
there is nothing. Simplicity of 376 2ND.
Investigation is open, my lord. So,
you are appearing for?
Okay, number 2 informant.
What do you say?
I have not lost any allegation against the present petitioner. Only secretary. I have lost against the secretary.
What to do?
They are present in the court, madam.
You got the bail.
Nah.
You applied or it was rejected? Rejected.
First or second or?
You could not own over them during bail
ମୁଁ
stage.
ଆগে ନାଇଁ ଓନ୍ ଓଭର ନାହିଁ ମୁଁ ଆଜ୍ଞା ସେତେବେଳେ କାଉନସିଲ ନଥିଲି
Now
after madam verifying the
now only you could case
no
them.
no madam after verifying the FIR I was astonished when the FIR is allegation.
Why? Where is your bail? Let us see the bail order. It must be very curious.
Mobile bail order ନାହିଁ bail order rejected. I mean rejected no first or second or?
My lord,
ଲେଖିଛି ନା
Then why don't you go and first hour, second hour? You go.
ଭିତରେ ଆଜ୍ଞା କେତେ ବର୍ଷର
my lord, may
ଲେଟି ମାଇଲ
may I take instruction from the concerned?
See, what is this? In 376.
Yes, ma'am.
She can't be an accused. I can understand if there is something abatement or 120B or something. I can understand. You charge nothing, and complainant comes and says that I have not made any allegations against her. I made against secretary. And unfortunately, she burned her finger by going to the court and asking for bail.
ସେଠି କଥା ନାହିଁ କଥା ହଉଛି ଯେ whether charge sheet has been filed or not and number
Charge sheet has been filed
and the deposition has been taken note on.
No deposition ହେଇଛି.
Deposition has
No charge
file is
sheet
going on.
A charge sheet it only says 376 2 ND.
That is altogether different. You'll also may kindly see the deposition. Page annexure 4, page 40.
40.
Page 40. Yes, 40.
Okay. Let us read what are the allegations.
I am the informant.
She is the informant. Huh?
Yes. The victim is my younger sister.
Yes.
I know accused Kunja Bihari Das, who works as a teacher.
He is facing trial.
Yes, yes. Next, read.
Nivedita Lutheran Mohila Samiti, Nivedita Ashram at Patila Pong. In the year 2014, victim was staying with her husband in our house at Manipur. The husband of victim, after quarreling with my father over land issue, killed him and in jail in connection with that case. As after death of my father, the financial condition of the house was not good and victim was then pregnant and caring for 7 months. We decided to shift her to an ashram for her proper care and maintenance and contacted Nivedita Ashram, Prabhat Bhuya, Minati Bhuya, Basanti Bhuya, who were managing the ashram. Inspired us to take care of the victim, so we left her in the ashram. After the victim was left in the ashram, she gave birth to a child the month of September. During the childbirth, my mother attended the victim and also stayed with the victim for some days in the ashram to take care of her. The ashram management allowed us to meet the victim and her child for about 3 months and thereafter did not allow us to meet the victim or her child. Since then, we are not in contact with the victim, but in the year 2021, on 8/4/2021, we came across a news in a Udia Delhi that victim has given birth to another child while staying in the ashram. When we approached the victim in the ashram, she told us that one Kunja Bihari Das who comes to ashram to teach the inmate forcibly kept physical relationship with her and made her pregnant. On this same day, after hearing about the incident from victim, I proceeded to Marsagai PS and lodged FIR. The victim also told us that rupees 1,44,000 which she was entitled to get as pay towards her service as maid servant in the ashram had not been appropriated by ashram management and the same had not been credited to her account. We also came to know that the ashram management sold out her 2 children against her will. I reported all these facts in my FIR Exhibit 1 is the said FIR on which Exhibit E1 by 1 is my signature. The FIR was
there is nothing against her. Whether she is the president of the ashram. Who is she? She is Bromila Tripathi.
Why she has been named?
That's
If not, she is not being named in the, then why she has come up before this honorable court?
ଆମେ
That is
ଚାର୍ଜସିଟ୍
the
ଲେଖା
cause
ହେଇଯିବା
of the
ତାଙ୍କୁ
case.
ଆରେଷ୍ଟ କରୁନୁ
No,
ବୋଲି
Bishop, unless until I get the entire documents,
No, you
ଆଜ୍ଞା
must,
ଚାର୍ଜସିଟ୍ ଲେଖା ହେଇ ତାଙ୍କୁ ଆରେଷ୍ଟ କରୁନୁ ବୋଲି
no, you must,
No, no.
you must get,
there
no,
is
no.
something. is
Whether,
there.
what is he the president of the ashram?
ଆଜ୍ଞା
Is he the president of the ashram?
ହଁ
Ashram.
ହଁ
There is allegation in ashram management.
ହଁ
That is the reason they have roped in.
ନାଇଁ ନାଇଁ ମାସର ଆଣିଦେଲେ 376 କୋଉଠୁ ଆସିଲା ଆଜ୍ଞା
376 not.
ହଁ
Investigation
ଏବଂ
open ଅଛି.
Allegation is ashram, they might have sold the children.
ହଁ
Yes, that is the
Ashram,
probability.
that is the allegation.
ହଁ
What is the, where is the allegation against her insofar as 376 is concerned?
It's 76, no?
This is the examination there in the court.
ହଁ
You will be acquitted. You will be acquitted.
ଆଜ୍ଞା ମୁଁ ଆରେଷ୍ଟ ହେଇଯିବି ଏ ବୁଢୀ ଲୋକ ଆରେଷ୍ଟ ହେଇକି ଭିତରେ ରହିବ ତାପରେ ବେଲରେ ଆସିବ ୟୁ ଲର୍ଡସିପ୍ କାଇଣ୍ଡଲି ସି
That is instruction.
ଆଜ୍ଞା ପ୍ରେସିଡେଣ୍ଟ ନାଁରେ ଏଫଆଇଆର ହେଇନାହିଁ they have registered against the FIR. Now the informant coming before your lordship saying that I have not placed any FIR against her. Police charge sheet ଦଉଛି କଣ ନା ସେ absent ଅଛନ୍ତି ମୁଁ charge sheet ଦେଇ ପାରୁନି
Yes, Mr.
That is the vital part. Only one thing is left to be taken. Instruction whether charge sheet in the meantime has been filed or not against this petitioner.
ନା ନା ହେଇନି ପରା ଦେଖାଯିବ
Because that is open. 173(8) is open.
open for what next page ଦେଖ
ଆଉ ତ କିଛି ନାହିଁ
ଆଉ?
pending for arrest of other involved accused persons.
ହଁ ସେଟା କିଏ
ସେଟା କିଏ ଆଉ
ସେଟା କିଏ
Kunjo Bihari has been arrested.
ସେ କୁଞ୍ଜ
Please
ବେଶ ତ ସରିଲା ତା
please
କାମ ସରି
specify.
ଯାଇଛି and keeping investigation under section 173 clause 8 CRPC the case is pending for arrest of other involved
Where is
accused persons.
where is the
କୁଞ୍ଜବି
complaint?
informant
Informant. Just Mr. Maharaj, yes, sir.
The brother of the victim.
Brother of the victim.
see he is the informant and his deposition was read before your lordship
The was subject to condition that all the 6 accused persons shall pay 1,000 rupees each to the victim, opposite party number 2. 1,000 each pay here. 6,000 ଟଙ୍କା ତାଙ୍କ ନାଁ କଣ ତାଙ୍କୁ ଦବୁ ମନ୍ଦାକିନି 6,000 ଟଙ୍କା ଦବୁ ଠିକ ଦେଇକି ରିପୋର୍ଟ କରିବ ତାପରେ କୁଆସ ହବ ଠିକ ନେକ୍ସଟ
Item 20.
My lord, I have entered appearance on behalf of the informant. A copy may be served on me.
Last time that matter has come, my lord.
advance notice.
Here in 319, some accused person have been added. We are facing the trial. My predicament is for trial of both the cases together because we are in the mid of the trial.
No, my lord.
Now under section 319, some accused person, those who are named in the affair, subsequently not charge sheeted. Thereafter, they have been added.
Material comes under control.
319. So I am facing the trial petitioner,
That
the
was before
petitioner,
your lordship.
and
No, who are you?
my lord,
You are the original accused.
I have the original. So because they have been faced the trial together, ସବୁ
Right,
ସାକ୍ଷ୍ୟ
right,
ଏକାଠି କାରଣ our 50 witnesses are the only, my lord, 22 charge sheeted witness has been examined.
My lord.
And now, my lord, we 319, some accused person have been added, and now
Why have you come here?
because, my lord, for facing the trial together both the cases. So, my lord, rest of the witnesses,
Separate.
rest of the witnesses, they will be examined for both the case for fair trial.
Okay,
Because
let's file the reply.
My lord,
Yes.
your lordship,
enters
your lordship was pleased to reject the application
opposite.
filed by the under 319, which was allowed under 319, that was challenged before your lordship.
Enters appearance on behalf of opposite party number 2 on advance notice and seeks time to file response to the petition. Leaves the matter on system.
And my failure to
No, no.
adjournment
No, that's-
petition,
It is under
because they have a
trial.
trial will that will
That will be
trial
split up.
only
When is not going to
only fair for adjournment
No,
petition till
Matter-
only fair for adjournment petition before the court will.
No, that is the indirect stay.
No,
Yes, yes.
I'm fixing a date. We'll hear.
Yes.
Separated trial has already been progressed.
So that don't scuttle trial at this stage. Let it, yes.
34.
Oblige.
34? Even in the second call, nobody appears. Urgent.
44.
July.
44.
44.
May I please? Your Lordship?
Even the,
Your my lord, the petitioner, my lord, filed the present application challenging the order under Annexure 3. Your Lordship kindly see. There, my lord, the offence under section 138 NIT, he has filed after receiving notice, my lord, the petitioner, the accused, after receiving the notice, he filed an application on 205 CRPC. That has been rejected by the court below. The petitioner is a businessman and he has also, my lord, in the petition side.
petitioner is businessman at others' cost.
No, my lord, your Lordship.
Take money, issue check, and then do your business.
No, he is also admitted that there is, my lord.
What is the check amount?
Check amount is, my lord. And I have filed the complaint case. The check amount is.
What is wrong in it? He says that 317 you can resort to. What is the wrong in it?
My lord.
Neither you will go nor your lawyer will go.
No, lawyer will go, my lord.
That is what his
the
court says.
concept your Lordship kindly see.
The court says that furthermore, the provision under section 317 CRPC can be resorted.
Decision, my lord. This honorable court also held that so far 130 is enacted, my lord. The accused present is not necessary, my lord. The accused will, my lord.
That is what the court also says.
But my lord, if my lord 205 will not allow, my lord, how, my lord, I will
issue notice. Issue notice. Issue notice to the court. What is the check amount?
Check amount 2,35,000. My lord.
Come with the check amount. We will finish here.
My lord.
Come with the check amount.
I will
2 lakhs something. We will fix installment, paid in 2 installment or 3 installment and finish it up.
My lord.
That's the best.
My lord.
Okay. Next.
And I have filed an application for stay, my lord, further proceeding.
No.
Unless, my lord,
complaint case. Nothing.
There is BW, my lord, issued your lordship.
So, thereafter what happened? BW. They'll come and arrest. 138 case, they'll arrest.
Now
NBW in 302, they are not executing.
My lord, not
and people are coming, NBW of 2009, they are coming here.
Now, my lord, because of the election, my lord, the old NBW are also, my lord.
I am not persuaded to issue notice also. I am only issuing notice because check amount is very small.
Your lordship kindly see the order dated, my lord, page 15, the NBW in the meantime issued, my lord, that is.
NBW issued on which date?
9/2/2023.
Shall be kept in advance till
My
date appears.
lord.
Item 40 Item 40 by 6. What? Item 40. At CPL. At CPL. 40. The initial 40.
Mentioned. Morning is.
Yes.
In this case, it is under a husband, opposite party wife. Wife filed while criminal proceeding under section 125 CRPC for a maintenance. Husband also filed civil proceeding section 9 of the Hindu Marriage Act for restoration of conjugal life. My respectful submission, both are tribal men. Entire allegation in 125 proceeding, they more ichha nahi mo rahibini. Court se kahuni je ame taku torture karchu. So my respectful submission, either proceeding dropped or kept in abeyance till disposal of the my section 9 petitions. Petitioner is very much interested to take back.
Is the maintenance how she will survive? You don't pay?
In tribal act, there is no. In tribal case, 125 not maintainable. Section 24 is open.
Don't go into technicality. How she will survive? You have to pay something. No entry maintenance is passed.
Both are filed. Both are pending.
Simply I issue notice, letter come. Issue notice, letter come.
Settlement
असला पर दिखे आसुन सेटल कर दो that first second we can give find the process fee let us yes
72
again item 72 your lordship has
the second time issued notice through special messenger and the noting was that they are in the joint family, someone else might have been received it. Because earlier what was in the through process, the restored post, one Lily has received, for which nobody has appeared. Subsequently, my lord's order
Just see.
directed for the special messenger. And noting that someone has been received.
Received.
Yes, your lordship. The register may show that in the meantime, someone has filed the wakalatnama. Right out.
Has he filed? Anybody has filed?
So, Sesare noting. Again.
And
that is the noting. The back side. The back side. No, noting the back side. Again.
You file good to
You special messenger.
Nice. Wakalatnama file.
Pardon?
Nobody has filed wakalatnama.
In the meantime.
Service is complete, huh?
Service complete.
Service complete.
Despite service on the opposite party number 2.
My lord, compromise. Both parties are present.
What is the offense?
Offense, my lord, minor offenses.
Minor.
294, 323, 354 D, my lord.
What was the litigation?
Following the.
Yes or no? Just see, check it out. Ask her. Ask the victim girl. Ask the victim girl whether she is really.
Yes, ma'am.
Just see. 424.
Prashant Muni. Pitobas Das. Balmiki Bishu. Kirot Behra. Suman
Bhatia. Suman Bhatia.
At the instance of opposite party number 2, FIR number 4 came to register. Allegation against petitioner that the opposite party number 2 opposite party number 2 has lost their FIR. Inter alia, alleging that while the on when the classes were going on, opposite party, sorry, petitioner number 1 and 2 forcibly entered into the school and threatened that the opposite party number 2 that he is providing nasty food to the student of the school. Therefore, they demanded money and threatened the opposite party number 2 to publish the same in the newspaper. Opposite party number 2 paid 18,500 through one Firod Behra to the accused persons for not publishing the same in the newspaper, and thereafter filed the FIR on 23/9/2020. After investigation, charge sheet was filed on. When charge sheet was filed?
Charge sheet, my lord.
Yes.
The other vice lordships.
Exact date.
30/10/2022.
30/10/2022.
Yes.
When before the trial commenced, the parties have settled that. The petitioner and opposite party number 2 are present in the court, represented by the prosecution.
They filed a joint affidavit dated against the interim stating that they have settled the dispute and the money was taken by the opposite party. And money taken by the forcibly taken by the opposite petitioner has already been returned to the opposite party. The opposite party therefore doesn't want to proceed against the petitioner. Mr. Raghunath appears, Mr. Maharaja appears for the state, it submits that the dispute to the interested parties since they have settled the dispute and the disputed amount of 18,500 has already been returned to the opposite party. Therefore, there is no legal impediment to possibility. Taking into the taken on record.
Item 10, my lord, also directed all the petitions to give 6,000 rupees, my lord. They have already given and they received. So that, my lord, again she will not come and. Yes.
First,
10, item 10.
put it in the record.
Yes.
Yes.
86.
It's a case of my lord.
Well, I appear for the petitioner in this case.
Have you read my judgment?
That is not uploaded yet.
That is squarely applicable for our case.
What I have said is primarily for even for the interim release, the prime consideration is the welfare and of keeping up with the cattle.
My lord.
The court has to consider that aspect first. Even if somebody is claiming to be the owner, he doesn't have a superior right. The only consideration is you have to see whether the cattle were properly kept or upbringing has been done or not. All this.
Exactly.
So on that basis, this matter.
Lordship call it on Friday, by the way. In the meanwhile, we'll have a look at the judgment and give back.
Otherwise, set aside and remit it back in the light of that judgment.
Let me just have a look at the judgment, subject to Lordship kind consideration. That order, my lords, if your Lordship kindly enough to see that judgment itself, in that judgment, they have referred to that very part itself and said that all these issues have been dealt with. In that the way that Lordship is presenting it right now.
Okay, let us see.
Today, just show it for your Lordship.
Today it will be uploaded. You see Friday.
Your Lords, for the meantime, your Lordship may kindly protect us, my lord, because the police now.
Friday I am taking.
Your Lordship, why I am saying, my lord, violate.
Police does say anything you see them.
Non-compliance, my lord, non-compliance order of the SDJM, they will register 406 my lord.
Don't precipitate.
My lord, learned counsel appearing for the OP2 will not precipitate over the matter, but the police will register a case under 406.
Police is bound by law.
My lord, so for that reason, my lord, I am praying no coercive action against the Gosala.
We are there to comply. Once your lordship direct, you are there to comply. So one judicial order has already been passed. That is to be complied.
But don't precipitate till Friday. We'll see because what is the application of that judgment. We'll see. Just instruct them not to proceed.
My lord, if the police will register another case, then we have to file another 482 to quashing of that matter.
Good for you.
Your lordship may kindly pass one order, no coercive against the petitioner.
Orders are not passed so casually. Because I am taking up it is Friday priority basis. Don't insist because see I have passed a judgment. If the judgment is applicable, then I will quash. If it's not applicable, then story is different. Casually, the stay orders are not being passed. I generally don't pass.
I'm not saying your lordship stay on the further proceeding.
I'll have to quash it.
My lord, I believe your lordship.
Don't have a case, I can't do it. As simple as that. So, hold on till Friday.
My lord, I'm not saying stay on the further proceeding of that judgment. I am saying pass an order for no coercive action against the petitioner Gosala, my lord.
I don't give no coercive action against the human beings.
Human beings of the animals won't be.
Animals are superior than human.
So you protect the superior right.
You protect this.
Friday.
Grateful.
Yes.
My lords, I here appear along with my lords, Mr. Sahu Matlab the
Yes,
problem is,
Mr. Raj,
matlab the
Mr. Raju, he has eloquently submitted, you might have heard it, Friday,
Matlab that- matlab that's good.
the judgment, we are uploading it, just see.
Matlab
What will be the applicability?
That's okay, Malas. The problem is the police is coming, Malas. They are threatening us with the FIRs. They are giving lots and lots of pressure upon us.
Nothing will happen now. Mr.
No, sir.
Mr.
I
Maharaj
have
has
CCTV footage, sir. I
Malas,
have CCTV footage.
only request, Malas. May I only request? Let Malas, may I only request? Let learned people tell the SHO, the IIC there, that he will not, Malas,
They
pressurize.
are very responsible lawyers. Once they told in the court, they will do it. Don't worry.
Grateful, man.
87.
Yes. 87.
87.
Revisions.
My lord, 320, 325, condition 6 months, fine 2,000 rupees, my lord. And default 2 months. And
Concurrent finding.
My lord, both the courts, my lord. And so far,
What to do? Last time, learned counsel for the petition seeks judgment.
Once we engage, my lord,
Nobody
one of
comes.
the counsel, they are requesting, my lord, so that it is.
I have to appoint application.
Engage one of the counsel. Mr. Sahu, my lord, here, my lord.
No, my lord, no.
No, he is interested only to protect
cows.
Cows. He is not interested.
He may, my lord, engage.
You assist in this case.
Okay, my lord.
Mr. Sahu is.
No, my lord, your lordship already engaged me in one matter. I think
Day after tomorrow. Get ready by small matter.
My lord,
Just tell him what.
325 only.
325 will.
That may be converted to the final, my lord, that's
Grateful, man.
Mr. Patnaik also should be, you should also be get engaged in a few of the revision matters. Assist the court instead of protecting kettles.
My lord.
Protect yes.
88. May I please, your lordship.
Hey,
So on
this is day after.
My lord,
Day
your lordship may kindly direct reflect the name, my lord. Because
Reflect the name, no?
And
Like it's appointed. Mr.
grateful.
Yes.
And a copy of it supplied to Mr. Sahu.
Oh, copy.
Copy supplied. Yes. Yes.
May I please, your lordship. Lordship, on last occasion, lordship wanted to know whether the person is alive or not. That
My lord, the report has come, my lord. Dead, my lord.
Date.
My lord, may abated, my lord.
I mean the on 8/4/2024, a report was sought from IIC
Gossipura.
Pura, yes, regarding the status of the accused person. And report dated 16/4/2024 has been received from IIC Gossipura in Australia. He in the report has informed that the sole accused,
Sole accused, my lord.
sole accused has
Died on 26.
died on 26/8/2019.
And the son of the accused also given this death certificate, that is on the reverse side.
The death certificate has also
Supplied
been
by the son
collected
of
from
this.
the son of the accused petitioners. The same is taken on record. Report along with the certificate is taken on record. The revision is
Abated on
awaited.
under 394 of 5.
Awaited under 394. ठीक है, disposal.
394 na.
चलो.
89. Pardon to mention, my lord. 87 ta next week.
87.
87.
Arre, I have you didn't come, then I have appointed amicus curiae. Anyway, since you have come, amicus curiae will come.
Both will there, my lord. Mr. Sahu will there.
Mr. Sahu will also be there. If you can't come, he will also be assisting. You also will come. No problem.
Yeah, party.
Day after tomorrow.
Yes.
Day after tomorrow.
Yes.
Mrs. Sahu, the petitioner is also there. You assist so that we will finish it up. Okay.
89.
May I please, your lordship? In this case, my lord, the petitioner faced charge, my lord, for offence under section 376 and 366 of IPC, my lord. In course of trial, my lord, he has been acquitted from the offence under section 376 of IPC, my lord, and convicted under section 366, my lord. The ingredient of offense 366 matter is part of 376 matter. There must be some illicit forcible relationship or for marriage. So where marriage party is concerned, there is no allegation to that effect matter. When he has been
366.
matter, when he has been acquitted from the offense under section 376 matter, then the conviction under 366 is matter not appropriately made out the ingredient of offense matter. Do you see kindly? That's offense under section 366 of IPC.
The kidnapping, abducting, and inducing women to compel her marriage.
Whoever kidnap or abduct any woman with intent that she may be compelled or knowing it to be likely that she will be compelled to marry any person against her will, or in order to that she may be forced or seduced to illicit intercourse, or knowing it likely to she will be forced or seduced to illicit intercourse, shall be punished with imprisonment. Here, so far marriage party is concerned, that is not there. Only for purpose of illicit relationship. When he has been acquitted from the offense under section 376, the conviction under section 376 is absolutely not made out.
What the appellate court says?
That appellate court, my lord, says, my lord, he also that accept that 376 is not made out, even if there is some illicit relationship, my lord, that is
Show me.
that is page 10, para 11 of that.
Page 10.
Page 10.
Para 11.
That is conclusion part, my lord. Description, that is there itself. The victim has stated it in clear terms that
Where are you reading?
Para 10, 11, my lord. That
Para 11.
that para 10 has been vividly mentioned, my lord. That para 11 short
Stated.
my lord. One night with appellant inside a forest when she was raped 3 times. Of course, the Law and Lower Court has recorded an order of acquittal for offense under 376 IPC is concerned. The offense of rape may not be found to have been established even though there was sexual intercourse. There is no doubt that victim was taken to forest that might be seduced illicitly. On this matter might be seduced, and there is no forcible intercourse that has been acquitted from the 376, and he convicted under he confirmed the conviction under 366 matter. I have also brought while the trial court while acquitting has specifically stated that no offense under section 376.
This is the order of revision court.
Appellate court matter. That I have also brought one citation of this honorable court when 376 this honorable court also clear that.
1 minute. This is page
376. That is 2009 42 OCR 819, my lord. Honorable court. There he acquitted under section 376 and also confirmed that 366 and 365 he has been also acquitted, my lord. Sir, here the learned
Which paragraph? Which paragraph? Complete.
That is my lord, that is last paragraph. Such being stated under natural evidence, there is no scope to hold that petitioner is a reliable witness and uncorroboratedly testimony convicted the appellant for offense under section 365 and 366 IPC for kidnapping and under section 370 for rape can be based. There he disbelieved the victim and he has been acquitted from both the offense 360. My lord, so there are facts some different, but the ratio is same, my lord, and this is the ratio. The internet
89 na?
My lord. This is
Page
the
14, paragraph 10. Though the accused has been acquitted from the offense 376, my lord, not proved, my lord, but para 10, my lord, page 14. Now let us scrutinize the evidence on the record to see how far the prosecution has proved its case against the accused.
Page 14.
The judgment, my lord.
Appellate court.
Paragraph 10.
10.
My lord.
Yes. Pointing out the above stated facts and circumstances.
Now scrutinizing the evidence. Page 14. Page 14, my lord.
14. Total to 11 pages.
No, arrota. Trial court.
Trial court.
Trial court, my lord.
Okay.
Charge 376, my lord. Paragraph 10, my lord. Of trial court.
Front door never, my lord. Front door never.
468. IPC, Pedol 9 has stated that the victim left with the accused Shesadeva On the date of occurrence, P-double 10, the victim has stated that the accused Seshadeva took her by dragging, holding her hands to the nearby push and stayed.
The petitioner number 2 has already died, your lordships.
90, eh?
There are two petitions.
The two petitioners.
Two petitioners.
My lord. 334 IPC, 2 years RI.
What about one?
Your lordships, one he is alive, but your lordships, the two has already died. He is the father of petitioner number 1.
Yes, you. What are the allegations against one?
No,
Both
that
of
is
them are
three-
convicted, huh?
Not both of them convicted.
Three-
Under which
306.
306.
306 and 34 of IPC.
RI 2 years.
Husband and father-in-law.
Father-in-law.
Husband, father-in-law.
My lord.
Yes, your
My
lordship.
lord. 498 is there.
Husband, father.
498.
Hmm.
34 for DP Act. My lord, the convicted under 306.
Are you ready to argue?
Your lordships, let the matter may come some other day. I'll get prepared and argue.
Okay. Learned counsel. Counsel, the petitioner submits that insofar as there are two accused persons in the present case, and the accused number 2 has already been died. Therefore, the present revision petition qua accused petitioner number 2 stands abated stands abated, and the revision petition qua the petitioner number 1 is deferred till date लिख दियो, first week लिख दियो, for Sunday. Yes.
Name.
He has written. What is your name, ma'am?
Soumi Das. SOUMITAS Das.
Soumi Das. Yes.
Item 91.
Grateful.
Yes.
The petitioner has been convicted of 324 million.
324.
Yes, the appellate court maintained the conviction but reduced the sentence from 2 years to
1 year.
1 year.
2 is to 1 year.
Yes. Basing on the statement of evidence of P-double 3, 1, 3, and 5, the conviction has been
How much you have already undergone? How much?
undergone. All through I am on there.
Okay.
Custody give me.
324. 324, huh?
Well,
324.
I am in the counter case. Madam.
There are cases.
On the counter case, the victim in the first case, he is accused in the case. He has been convicted on 307. Against 307, I am in 324. There are a lot of discrepancies. My lord. Basing on the witness of the interest witness, there is no independent witness. And even though there are independent witnesses, they are not examined.
Injury in the head.
No, on palm, left palm, left palm and back side. They say, but the IO say that I have not stated about anything about the whether the knife is blood stained or not. I have not mentioned. P-double-9, your lordship. In cross-exam, he says that I have not stated anything about the fact that the knife is blood stained or not.
Where are you reading?
P-double-9, your lordship may see. LC after
P-double-9.
P-double-9 or para 5 देखो.
Yes. Yes.
I have not para 5 or 8 देखो. I have not mentioned the size of knife in the scissor list. I have not mentioned if any blood stain was there on the knife. So that's P-double-9. P-double-3 की से बेस करी करछन तो P-double-3 टा देखो.
Kindly see the statement of PW3. The sub interested witness, tankari family. Paragraph 2, your lordship.
Two of trial court judgment.
Yes. No. Judgment mo dekho mo witness kotha kohchi jo. Witness ro evidence ta PW3 ro statement. Para 2, your lordship. Police Babu seized nothing in my presence, but obtained signature in a paper. Exhibit 2 is my signature. Cross-examination asila, about 20 to 25 persons out were present at this spot, but no one was examined. No independent witness was examined. 4, 7, 8 were independent witnesses. They have told
What are the reasoning?
से सिविल डिस्प्यूट थिला सिविल डिस्प्यूट रे ताकर छात एक्सटेंशन रे ताकर गंडगोल होइछ बोली कहू नेबर्स दे आर नेबर्स ସେମାନେ ଫାଟାଲ ଲେ କରିଛନ୍ତି ଯୋଉଥିରେ ସେ ନିଜେ ଆକ୍ୟୁଜ ସେ 307 ରେ କନଭିକ୍ଟେड
But PW7 and 8 are independent witnesses.
Then
PW 3, 4, 6, 7, 8 are the eyewitness occurrence, my lord. PW 10 is the doctor, my lord.
Doctor.
The reader of the my lord evidence of PW 1 trial court judgment
Victim.
One is the victim inside.
Paragraph 6, my lord, of trial court judgment. Page 22. PW 1 is the informant victim of this of the occurrence. His evidence reveals that on 27/12/2004 at about 8:30 am, his father was measuring the roof of the accused Girish Meher as the roof was being extended towards their house. He has further stated that when the measurement was going on, accused Girish Meher abused him in Fiji languages and on hearing his words, he came out from his house. His evidence further reveals that accused Girish called other accused persons who came being armed with sticks, lathis, knife, etc. According to him, accused Girish Meher and Hemant Meher got hold of him and accused Girish stabbed him by knife at 2 places on his back as well as assaulted on his left palm by that knife. He has further stated that due to knife blows, he sustained bleeding injuries and that accused Girish has also dealt knife blow to his brother Labo Meher and mother Gurubari Meher. He has also proved report by the Exhibit 1 submitted at PS. PW 2, my lord, another witness, brother of the informant, an injured victim of the occurrence. His evidence reveals that on 27/12/2004 at about 8:30 am, the accused Girish abused him, PW 2, father in filthy words, when his father was measuring the roof of Girish. According to him, accused Girish called all the accused persons who came being armed with the lathis and sticks. Accused Girish was holding a knife. He gave knife blow to the PW 1 on his back and hand. He has further stated that when he went to rescue PW 1, accused Susili and Mohendra got hold of him, whereas accused Girish Meher dealt knife blow on his back, causing bleeding injury. According to him, accused Girish Meher had also
How will you get over this injured witness?
And PW 10,
my lord,
doctor also, my lord, PW 10 at page 25, my lord.
ये जो लाठी फाटी
Paragraph 10.
that has been disbelieved by the court.
10 also.
10 also, my lord, there are doctor examine injured victim. His evidence is that
Incest wound.
my lord, 3 injuries are there, my lord.
Say knife
And the medical evidence and also the occurrence are tallied together, my lord.
But how will you get over the injured witness statement?
Exactly.
ना ये जो पढ़ले एगुड़ा सब डिस्प्ले that has been displayed by the court जो लाठी फाटी जो सब लिखा है
So knife
that
tag
has been displayed by the court.
but there are 4 accused persons faced the trial. This
They have been
also, my
acquitted.
lord, found guilty since he has dealt the knife blows.
Others have been acquitted because the court has disbelieved that those story that he called all other persons
trial court,
those have been disbelieved.
Trial court will confirm they are but reduce the sentence, my lord.
Reduce the sentence to
1 year.
1 year.
2 years to 1 year.
We will further reduce.
Reduced to cash. Convert.
Cash as well as some sentence.
No, man. Consider other alternate throw.
There is a provision of fine also. How much fine?
That's the fine amount, my lord, the heavy fine amount, heavy fine amount may be imposed and some amount will release if the injured person salary.
357. How much you?
instruction କହିପାରିବି କମ ଟିକେ କରିଦେବୁ ରିଜନେବଲ କରିଦେବୁ ଆଉ ନହେଲେ କହିବ ମତେ ଇନଷ୍ଟ୍ରକ୍ସନ
Converted fine, not see one.
57.
50,000 ଖାଇବେ
ନହେଲେ କଷ୍ଟଡି ବେଲେ ପୁଣି ଗୋଟେ ବର୍ଷ 6 ମାସ ରହିଲେ ତ ବହୁତ ସାରା
Otherwise, 3 month sentence and 10,000 rupees.
ଆଉ ଗୋଟେ ଥାଉ ନହେଲେ କୋଉ ମୁଁ ଟିକେ ଇନଷ୍ଟ୍ରକ୍ସନ
We are not under the mercy of accused. He will say, give instruction to us.
ନାଇଁ ନାଇଁ
What sentence will pass? Will
Sentence-
pass the sentence?
No, no, no,
Conviction
no,
is maintained.
that is not sentence ପାଇଁ
I will not interfere in conviction.
ପୁରା ଫାଇନ ପାଇଁ ପୁରା ଫାଇନ ଦବାକୁ ରାଜି ଅଛି ନା ମୁଁ ସେଇଟା କହୁଛି
See, Rajiv knows that's not an issue. We should,
50,000 ରୁ ଟିକେ ରିଜନେବଲ
I'll make 3 months and 10,000.
नहीं लॉर्डशिप में waive the sentence lordship में
I'll
reduce the fine lordship consider
357 employee and you pay. I don't know. Judgment reserve.
lordship में
Fine, huh? Fine 50.
only fine
Conviction maintained.
Fine
That
of
is
50,000
converted to fine. Yes.
92. Yes, sir.
Yes.
Master ଆସିଥିଲେ ବିପ୍ଲବ ଦାସ they are married, but in fact
Conviction 324. 1 year, my lord.
Sentence?
1 year. RI.
Injury where?
My lord.
Head?
My lord. Injuries are there, my lord. In fact, he is present in the fact, my lord. Lip. At sustained bleeding injury and at a last stage. Tooth.
Next week may record. None appears for the petitioner in the interest of justice adjourned to next week. That's
93.
93. Somebody is there will do. Yes.
Discuss petitioner 2 is died. Petitioner number 2 is died.
Yes. And what about petitioner 1?
Petitioner number 1 and 3 matter.
1 and 3.
The conviction 2 years matter. Conviction 2 years and petitioner number 1 court told the Bhubaneswar Sagaria, my lord. He is the injured, my lord. Bhubaneswar Sagaria is the injured.
First of all, write down. I'll link this by it is informed. The 11th Court of Orissa submits the death certificate of opposite party number 2.
Petitioner 1.
Which is taken on record.
It's
The revision petition for the opposite party number 2. Opposite party petition number 2. Present revision petition for the petition number 2 is stands awaited.
My lord, allegation that the petitioners number 1 and 3 and one Sanasanda whose daughter had given a love letter from Bhubaneswar Sagaria, no, from Deepak Sagaria. Deepak Sagaria has written a love letter to Sanasanda's daughter. But nothing has mentioned in the affair. It is a doubt. It is on surmises and conjectures. It has been stated. On the hateful incident on the occurrence date, the petitioner number 1 and petitioner number 3 went to the Prabhakara Sagaria, the informant house, and called his elder brother to come and attend the punch meeting to decide this matter, decide this case. Thereafter, on the way at the Madhavati, the petitioner number 1 and petitioner 3 got hold the Bhubaneswar Sagriya, and petitioner number 1 slapped on his cheeks, gave a slap on his cheeks, and petitioner number 3 dealt a stick blow, lathi blow on the backside of Bhubaneswar Sagriya. This is the allegation, my lord. Your lordship, the examination conducted by the one gynecologist, not orthopedicians. The examination, and it has been stated that two injuries are simple and one injury is grievous. And conviction is 325 and 323 and 34. 325 minor higher offense. If 325 will come, 323 will out into existence. My lord. Second thing, my lord, no weapon has been seized from the petitioners. Nothing has been seized. IO has not been examined. And my lord, one statement of the doctor I am reading, my lord. Sorry. PW5, my lord. DW5. Statement of doctor. On 2498, while I was working as ONG specialist, gynecology specialist, my lord, CSC Kontavanji, District Balangir, on that day, on a police requisition, I examined one Bhubaneswar Sagriya, son of Dura Sagriya of village put PS Kontavanji at 1:45 p.m. My lord. Injuries, fracture on both side of both left side leg below knee joint. One hematoma around takes at a simple podium, and one lacerated is of 1.5 inches and 1/2 inches at the center of the hematoma. 1 and 2 are simple in nature, and the age of the injuries were.
What are the findings of the court below?
Court below, my lord, on the basis of doctor's statement and the injured statement, convicted the petitioners.
How will you get about the injured statement? Injured witness are very dangerous witness.
Injured statement, your lordship kindly says, he stated that he was at the time of occurrence, he was lying on the road and police came, and thereafter he went to the police station, police examined, thereafter he went to the hospital. If he is injured and his leg has been fractured, first he has to go to the hospital, my lord. And the incident occurred 12 to 1 p.m. in between. And went to the hospital.
But his statement is corroborating with doctor's evidence.
No. His statement, he's stating nothing has been seized. No weapon has been seized from anyone, any person. I don't know. He stated. But a seizure witness stated one stone has been seized from the brother of the injured. seizure witness stated. But injured stated in.
Yes, Mr. Rahul.
I don't know.
My lord, the evidence of a PW2, the injured Bhubaneswar Sagaria, my lord. Bhubaneswar Sagaria. They revealed that the spot after some altercation, the Sanna Sunda caught hold of him and accused one who has been passed away, slaps to his face, and at the time of accused. My lord, the
Camouflage the findings of both the court. I'll
My
take it up day after tomorrow. Parthead, huh?
Yes.
Parthead, bleach the metal day after. Parthead, huh?
Interim order.
What interim?
Hind stage. Hind.
state also.
Stay the secure. I'm not.
State also.
Not Parthead, okay. Tomorrow. Day after tomorrow, Friday. Friday. Next.
94.
The petitioner has been convicted for the offense under section 409 and sentenced to undergo RI for 1 year and fine of rupees 10,000 in default. Default of fine, RI of 6 months.
Convicted under which section?
409.
Yes.
Petitioner was the sarpanch at the relevant point of time, and another Giridhari Kahara was the secretary of the GP. It is alleged that the informant PW4 has stated that PW4 has stated that while he was inspected the documents, he has found that both the petitioners have misappropriated a sum of rupees 75,461.50 paisa. And during the course of the trial, 8 witnesses have been examined. One is PW1 is the VLW, PW1 is the GPO, and in the cross-examination, the said witness has admitted that the secretary was the charge of the entire money. May I read the statement? The secretary is the custodian of records and the.
Where are you reading?
From the deposition of PW1.
Can you finish your today?
5 minutes.
Huh?
5 minutes. Full test.
Deposition.
ଆପଣ ready ଅଛନ୍ତି?
Deposition where there is.
Deposition ଜାଗା ନାହିଁ କେମିତି? ଦିଅନ୍ତୁ deposition ଦିଅ 4 ଦିନ ପରେ ଆପଣ.
Day after.
tomorrow. Okay. Yes. Continue. No? Can you any matter, urgent matter? This will remain in the board. It will be.
Item 95, your lordship. Register my diet to reflect my name in that case, your lordship. Because I'm always missing the matter.
Mr. Mahaparat's name to reflect the politics. 95.
Item 103. Today morning I was mentioning that matter. Your lordship may.
Day after. 103.
Item 97 or
95 next week actually.
Next week 95 करते हैं.
Okay.
बाकी जो मैटर था for your
item 97, 98 next week lordships.
Next week नहीं roll over कल परिपेरी नहीं
Yes lordship. Yes.
Board था so that at least things will start moving, you know. Board था. If you can't do, we will accommodate.
I can do lordships. 98 I may pray any
no
next day.
You tell me tomorrow.
Yeah.